Serial number 15, madam. Serial number 15. I'm appearing for the appellant. Because the counsel on record is hospitalized. May I request for 10 days time, my lords?
You will go in January.
My lords, may I request any date in December, my lords?
Not possible. Earliest possible will give. 9th,
Serial number 24, ma'am.
10 over to 9th January, and you will be requested made on behalf of the appellant that the senior counsel who will be conducting the appeal is indisposed health.
Serial number 37, my lord. A week's accommodation, scenery is annual.
27. What is it about? Green bench.
It's a department matter. 37, no? 37.
It will go to 16th January. 27.
37.
37.
Serial number 24, ma'am.
67 will go to. There is a delay, will issue notice.
Please, ma'am.
There is a delay of 65 days.
Please, ma'am. And there is we have filed application for stay, my lords. We have also filed an
And
application
notice
for stay.
written on 16th January. Already issued. All this 10 over to 16th January as requested.
Serial number 24.
Yes, one by one.
3 weeks was given for complying with the already 3 months, but still the matter is not being discussed.
Will be in January only. If you want to wait for early posting, you wait.
Any date can be
16th January.
24, my lord.
24 you are withdrawing.
My lord, there's a memo for posting, the 2023. My lord,
Learned advocate, Mr. Dimandika. What your name? Concession, so appearing for learned Dimandika Gowda, 6 permission to withdraw the present petition by filing memo dated 26/11/24. The memo is taken and record, which it mentions inter-alia that the petitioner has received the environmental clearance certificate as per the prayer in the petition, therefore the petition is no more required to be prosecuted.
Serial number 11, my lord.
Drawn. Any of the above.
Serial number 11, my lord. Serial number 11, my lord.
Yes.
My lord's memo for posting. The respondents have failed to furnish securities as directed by trial court, but they're making hectic efforts to alienate the properties. Therefore, we request that there's a grave urgency, and therefore we request to be posted to tomorrow.
10th January. January.
my lord,
Serial number 11, my lord.
Serial number 23, my lordship. Short accommodation, my lordship. Not
PIL. Let it be called out. What is PIL?
short accommodation.
My lord, at a serial number 11, my lord. Writ appeal number 991, my lord, 2024. With the connected writ appeal number 127/2024, the honorable court tagged this matter for listed 4/12/2024, my lord. The writ appeal number 2024, 127/2024, in that matter, list the serial number 11/991/2024 on 4/12/2024, my lord. Therefore, this matter also may be listed on 4/12/2024.
We do not. Bring the order. Give the order if it is there.
My lord, item number 13, my lord.
It is there.
now. Oh.
May be listed on 4/12/2024.
There is no such order.
My lord, in the writ appeal number 127/2024, to be listed along with writ appeal number 991/2024 on 4/12/2024.
This appeal shall be listed as per the order dated 6/11/24, passed in writ appeal number 127/24.
My lord, item number 13, my lord.
Fresh matter, my lord. The appellant is a nationalized bank. The writ petition has been.
Serial number 11, your lordship. They may be directed to serve a copy.
Will you permit the council to complete the mention?
Taken up.
Yes, ma'am.
The writ petition was allowed against the bank, my lords, directing the bank to hand over physical possession. However, I have to recover more than 5 crores. Now the respondent is approaching the bank every day to return the possession, and they are filing a contempt petition against the bank, my lord. Therefore, any date may be fixed, my lord.
It will be in January,
Any date, my lord, in January.
My lord,
17th January.
my lord, serial number 13, my lord.
Respondent bank has initiated proceedings against appellant, my lord. Appellant is running educational trust. They are taking a steps to auction the property mortgage in favor of respondent. And there is a request for tomorrow, my lord. There is an educational trust.
4th
There are about 200 students studying in the college, school.
4th February. If something happens, you file IA.
My lord, serial number 13, my lord. My lord, the parties are now trying to, I believe, explore a settlement, my lord. My lord, the date may be given, my lord, we'll report.
It was stated by learned advocate
My
Mr.
lord,
For
serial
appellant, my
number
lord.
30.
What's your good name?
A. Chaudhary, my lord. AC,
Achishaman Chowdhury.
please, my lord.
Stated that the parties are engaged in the talks of settlement. In that view, we requested 2 times, stand over to 4th of February.
My lord, there's a memo for posting, my lord, there's a contempt matter. Memo for posting, there's a contempt matter from 2023. My lord, the complainant is a very aged man and he's in desperate need of funds. It is tied in the hands of the BDA, my lord, it may be kindly listed.
Please repeat. Contempt matter.
Please, my lord, 2023 contempt matter. My
Wait,
lord,
after reopening.
the complainant is very aged and he's in desperate need of funds. It is tied in the hands of the BDA, my lord. It may be kindly listed anytime.
It must be, date must be given, some date is there.
My lord, it was previously listed on 5th of February. There is no
It
date.
is already listed on 5th,
No, my lord, previously.
previous. If there is no date given, then 12th of December.
Please. Much.
No date. Any mention through VCs? And permission. Contempt matters, list 1, seal number 1.
I must writ appeal has been
Tell
received,
Mala.
my lord. Writ appeal has been preferred, my lord, since this night.
There is no stay in writ appeal, my lord, and for 4 times it is being coming for non-compliance of office objections itself, my lord. My lord, from 1999, he is running around the courts, my lord. He is an ex-serviceman. He has filed so many writ petitions and they have not still complied, my lord. And
Writ petition was disposed of by on a single judge as per order dated 18th July 2023. The operative order reads as under and bracketed portion, page 26. Full stop on the bare reading of the aforesaid order. Although the respondent number 4 is directed to allot the land to the petitioner, no time limit is fixed for the implementation of the said order by on a single judge. Paragraph. In that view, it could not be said at this stage that any contempt of court is committed, much less willful contempt by any of the respondents. The contempt petition at this stage is not mature to be adverted to for its prayer. At the same time, paragraph. At the same time, the directions of the court should not go uncomplied with. Full stop. Therefore, it is directed that the respondent number 4 shall comply with the directions within 6 weeks from today, failing which he shall be exposed to the contempt of the court.
Lord's writ appeal has been filed.
Writ appeal, it was stated at this stage by learned additional government advocate that Mr. Pramodini Kishan, the writ appeal is filed in respect of the order. Which is
there is no interim stay.
It is provided that the parties shall abide by the orders which may be passed in the
Please,
writ appeal.
writ appeal.
Seal number 2. The
Much
person
of
DP.
So, madam, you must take orders in that writ appeal within 6 weeks because
Yes.
6 weeks is time is granted.
Please, my lord.
Seal number 2.
Time for the complaint in this matter, my lord. It's now matrimonial proceedings. In that,
What is it? What is the direction? There is no direction.
in this, my lord, the MC proceedings is transferred from Bangalore to Bangalore to try and dispose of along with the MC number 3720/2023, my lord, as per Annex A, page number 18, my lord. But after transfer of this petition,
Who has committed contempt?
wipe, my lord. The respondent wipe, my lord.
What is the contempt?
Herein, the matter is transferred from Bangalore to Bangalore.
You tell us what is the contempt committed by whom?
The respondent,
Which is
only sole respondent, my lord.
Hmm?
Sole respondent.
Sole respondents.
Please, my lord.
Srimati Shruti.
Please, my lord.
So what contempt is she has committed?
Initially, she has initiated the proceedings, maternal proceedings at Mangalore, my lord, and which is stayed by this honorable court. Subsequently, the maternal proceedings are stayed by this honorable court, my lord, in the CP proceedings. Thereafter, matter is referred to the Mangalore Mediation Center for amicable settlement. As per their instance itself, my lord. We have appeared before the Mangalore Mediation Center. However, even though she was present in the mediation center, she has refused to participate in the mediation.
So where is the direction to participate in the mediation?
No, my lord. Thereafterwards, we have reported the same to this honorable court. This honorable court, by considering this,
Where is the direction for against number 1 to appear in the mediation center and participate in mediation?
in page number 64, my lord.
Page number
64, my lord.
64.
Please, sorry, my lord. 96, my lord. Page number 96, my lord.
There is no direction.
Direction.
There is no direction.
There is page number 96. Both learned counsel submits
The
that.
submission on part of learned advocate Mr. So and so for the petitioner that respondent number 1 has committed contempt of the court by committing breach of the directions of the court, whereby she is mandated to participate in the mediation of the conciliation proceedings. Full stop. Neither order dated 31st January 24 passed in the civil petitions, nor order dated 12/9/23, which was earlier passed in civil petition number 370/23, could be said to be contained in such direction to require a, to permit, could be said to be containing such direction. No, the such direction is contained.
No, my lord. Kindly see page number 100, my lord.
Under the contempt of court of Act, full stop.
Page number 100.
The
It is,
contempt petition is thoroughly misconceived, dismissed.
in the meantime, one submission, my lord.
There is no direction, Mr.
For a-
I'll read petition if you want.
Not the, kindly, I will seek one direction to dispose of the MC petition in the hearing.
No, no.
Pa-
This is not a 226 petition.
Number 3.
My lord, for a moment, kindly see the page number 101. 100 and 101, my lord.
101, yes.
Please, my lord.
And there is no 101. The compilation ends at page 95.
In the last but 3 pages, my lord.
Hmm?
Last but 3 pages, wherein the order dated 31/1/2024,
Hmm.
wherein both the learned counsels submits that an attempt will be made to amicable resolve of the matter between the parties, and for this purpose,
You are not clear, you are coming, you are complaining in breach of which order? You are pointing out 3 orders. Which order is committed breach of?
in the,
And which order contains direction against number 1 to participate in the conciliation proceeding?
here in page number 101, it is
Which order you are bringing under contempt jurisdiction out of 3?
in this annexure A, my lord. Annexure A.
Sir, annexure is, then it is thoroughly misconceived. A is the order which I referred first.
First, my
That's
lord,
correct, that is a
Wherein?
contempt.
it is directed to,
There is no direction
kindly, the annexure A, page number 18, my lord.
with cost of rupees 5,000. Absolutely misconceived petition. It is absolutely misconceived. There can't be more misconceived petition than this as far as contempt is concerned. No cost, yes.
Number 3. Kavita HC.
Pay for the petitioner, my lord. Petitioner is a borrower. Respondent is the
Again,
bank.
there is no time limit in this. This
There is, my lord, 2
Where is
weeks. In
So-
para 8 of the judgment, my
The
lord.
right of it there.
My lord,
Notice returnable on 8 January.
my lord, before vacation, my lord, my livelihood is affected. My commercial property
16th
seized. my lord.
16th December,
16.
Number 4.
My lord, 18. May I-
18th December,
May I ask for it,
18th December,
Yes.
18th.
please?
Number 4. The Shiv Shankar.
Petitioner is part. Operative portion of the order is page number 17, my lords, next is C, my lords.
Page
Right.
number? Page
Page 17, my lords.
17.
17, my lords. Annexure C, page 17. Para 4 minutes. Red petition 5216 of 24.
Yeah, one second.
Let's petitioner is an unauthorized occupation. My lords. The land is granted in favor of the petitioner. My lords. In spite of granted of the land, my lords, the Tashildar failed to issue Sagwadi chitty. My lords. Hence, I filed a red petition for considering.
9 January, notice.
Number 5, the Chandrasekhar.
For the complaints, my lord.
Yes.
The learned single judge directed the accused number 1 to release the cell lead within 2 weeks, my lord. After giving the presentation, also the accused has not released the registered cell lead. Page number 9, my lord.
Notice written on 9 January.
This is number 6.
My lords, for the complaint.
Notice written on 10th January.
This is number 7.
This.
This is the sumo to PIL, my lord, which your lordships have. We have filed a report, my lord, with respect to the guidelines. There are also reports from some interveners, which have also come on record.
You filed some guidelines?
I beg your pardon?
You filed certain guidelines.
My lord, yes, my lord. We have
Suggest-
filed a report with, my lord, two really important guidelines. One is, of course, the
This regarding the mode of taking custody.
mode of taking custody of a child between warring parents consequent to a divorce. But also, my lord, there is another aspect which the court considered, and that was the psychological impact on the child, and as to how, when there is alienation of the parent or one of the parents, what should be the steps taken to ensure that the child gets the care and custody of both parents. And with respect to that, because of a specific fact scenario which emerged, which is recorded in the order of this honorable court, the court said that we must examine as to what other steps can be taken to ensure that the child gets an overall assessment by a third party. Therefore, my lord, we have placed before your lordships also one study conducted by the Child Rights Foundation, which has actually provided a fairly comprehensive report. My lord, kindly comes to page number, my lord, 114. This report, my lord, has been endorsed by the Bombay High Court and the High Court of Himachal Pradesh. And I am told, my lord, a couple of other high courts saying this should be followed.
114 is something else.
It's, my lord, I don't know if your lordships have the report of the amicus. No? My report.
Your report.
My report.
Micah's report.
No.
But sir, referring to this.
This,
114.
this, my lord, has to some extent been endorsed by the High Court of Himachal Pradesh and the High Court of Bombay, where in the absence of specific guidelines in the form of rules framed by the High Court, my lord will see the there is a fairly exhaustive mechanism prescribed for both for interim and permanent visitation, and also for psychiatric evaluation of the child and the parents as and when required.
Yes.
My lord, kindly comes to page 133 from the first chapter onwards. I'll only show your lordships the specific headings.
So other high courts have accepted this.
Beg your pardon, some high courts have accepted it.
2 high courts have accepted.
Bombay and Himachal Pradesh. I'm told, my lord, that this
MP.
report has also been circulated in Karnataka.
Karnataka.
Circulated but not enforced. It's circulated, but I don't think, my lord, any family court in Karnataka has ever given effect to any of these recommendations or acted in terms thereof. Then, of course, my lord, I have my learned colleague also has placed, my lord, a slightly different approach to it in our report.
What is the prayer in the petition?
Prayer in the petition, Lord, is to frame guidelines.
That is 2-4.
Page 9.
So we'll go through and pass what is to be submitted here.
There is, in our report, Lord, we have also provided a slightly different mechanism of making a parenting plan and an affidavit not to be filed. With
the report you have submitted is the basic guideline, which may provide basic guidelines.
Yes, one of them. We've improved on it slightly, my lord, from what was provided by the Child Right Foundation as well as the report of the Law Commission. We've
You are for, madam?
For respondent number 3, the Ayushman, the NGO, my lord, the intervening petition which was allowed.
My lord, based on our guidelines given to the, my lord, the union government, my lord, they have framed these guidelines.
This is to take, Mr. Chinnappa, this is to take in form, this is to be converted into form of some legislation or rules or not?
But until central government had said that they are coming out with some kind of rules for handling child custody issues.
Rules will be under the Act?
Under the Act, Guardian and Wards Act.
Guardian Wards.
But nothing has happened till now, because of which, my lord, various high courts have said we will enforce these guidelines which are there till then and ensure that all family courts as well as the high courts give effect to those guidelines. So that, my lord, there is some kind of a cohesive method by which it is done.
If the court requires the government to frame the rules in the lines of your report, then?
My lords, may I please make one submission, my lords? I appear for Union of India. My apologies for appearing online, my lords.
Yes.
We have given the guidelines draft to the central government, the Family Welfare Department, and they are seeking the help of one organization called Samvad, which is associated with NIMANS. Apparently they require to frame the guidelines, keeping the psychological aspects in view, psychological aspects of the child. So, they are seeking some more time to, finalize on those guidelines.
So you will be filing on the record of the petition? Your guideline will be filing?
Sorry,
You will be filing your guidelines here?
Please, I will place the guidelines on record, Some more time is required,
All right. When you will file?
Can I seek 4 weeks time,
What you are saying about the report which the council has placed on record, which Bombay High Court and High Court of Himachal Pradesh have accepted?
Yes.
Have you gone through that document?
We have placed it before the department, the legal section of the Family Welfare Department. They are yet to consider.
Coming out with some guidelines, then it is better.
So that can be done. Until then, Lord, lots, because this is an indeterminate timeline. We don't know what will happen and when it will happen.
Some interim.
I will come with some positive reply in the next 4 weeks,
Anyway, my lord, so far as the state is concerned, your lordships are, I think most states are framing their own rules and guidelines.
So you want some interim direction?
No, what I'm suggesting, of course, is your lordship may consider this, that the report which is there may be enforced strictly by all family courts, because I've not seen a single family court, though your lordships and the registrar has sent it to all family courts. Not once has this report been adhered to or given effect to, especially, my lord, in parental alienation cases, where one parent has the custody of the child and then alienates the other parent completely from the child.
This report is circulated in the family courts of
Yes,
the
Lord.
state.
I have one letter where
in our state.
In our state, yes. But that, I think, Lord, maybe some effect to it being given strictly will put some kind of a rule in how cases of this kind are dealt with. Otherwise, my lord, it is left to the sweet will. Actually, it's very difficult to find fault with anyone in a scenario of this kind. And it is extremely difficult for even a judge to make a decision simply on the basis of one interaction with the child.
We'll just apply our mind.
Right.
And on 17th December, we may take.
Yes. Yes.
Please. I'm grateful.
Yes.
I'm third party in person, sir. I'm a medical doctor. I bring a different aspect to resolve this issue of child custody. And it is our laws of natural law, medical science. So accordingly, it is the great injustice to the children. Millions of children are suffering. So many PIL have been filed, but they are not giving any relief to the child. So I bring my natural law. All the man-made laws are derived from the scientific natural law. And my laws are million-year laws, and it works at a molecular mathematical level precision. Now, 50-50, mother and father both contribute to get a child. It is 23 chromosome, makes 46, makes the baby. One less 45, one more 47, abnormal child. So one person does not produce the child, neither the mother nor the father. Both contributes equally. But at the time of justice, you give to one person and the other person suffers. The children are suffering. So many PIL have been filed, nothing is working. Why? Because it is the misuse of the judiciary. Because the law, according to the law, you are giving justice. But it is great injustice to the innocent children who are suffering. They say, give my 18 years back. You endorse the child custody judiciary. And then we suffer. Afterwards, one stroke of the pen, one endorsement, 18 years, child is gone. And he suffers day and night. And they are innocent. They didn't do anything. They did not select the fighting parents. So why they need to suffer? So it is not justice neither to the parents that you give 100% to one person. Other person has to suffer. The child is also suffering, breaking the family. This is not the justice for the children. So what is the justice for the children? Give their 18 years back. How it can be done is the all medical science it is there. That is the remedy. Now, this cannot be stopped, and this PIL will continue to be filed because it is the customary world law. ICJ 38B says at any time that any custom followed for long period, it becomes a law. So this is the customary world law. Since 1869, this custody is given to one person because you cannot divide and give 23 chromosome to both parents. So it is the, like since 1869, millions of children are suffering, 193 nations, because all member state nations have signed the agreement with the UN Charter. UN Charter, these are the deadlocks in the ICJ law and the UN Charter. Now, this is the customary world. If you have a divorce, you have to go to the family court for the child custody. The now supporting document is the medical science education issue. Wrong education to the medical doctors, but this is the way my teacher taught. So this will continue forever. So it is the 18th century, they are teaching wrong to the doctors, but doctors remain silent because this is the customary world law and the government has to suppress the new knowledge. They cannot allow it because Article 34 says that only the government can go to the ICJ, nobody else can go. So this is the deadlock. The customary world law will continue and the government cannot go to the court because they have signed the agreement with the UN Charter. So it is the whole link of the judiciary. Now, UN Charter is signed by the signatories who are political people and they don't know anything about the law, and who made the UN Charter law are gone with the wind. So there are no other way. Nobody has a jurisdiction to crack the UN Charter. Now, who will, that's why this thing will continue forever. This is the deadlock in the UN Charter. Now, all member state nations are bound to comply with the ICJ law, International Court law. And UN chief will not, and his staff will not answer outsider. So inside the organization, only the member state will never go and say that it is the problem, that they cannot forward it because they have to comply with the ICJ law. And outside person, if they say the chief will not allow or his staff will not answer, then how will you solve the problem? So these are the two, the supporting evidential proof is my medical education issue. The foundation of OBGYN subject matter is wrong. It's taught in the school. Both the things are taught in the school days, and universally standard. That these are the two diagrams. It's not my hypothesis, but why this diagram is there? Because this is the way my teacher taught. So it cannot be done because it is the ICJ law. So even though, and this is the copyright problem. So publisher says, I have the world copyright, bring the order from the world court. World court says we have nothing to do with the medical education. So it will continue forever. That means you are going up to the IVF and doing the treatment procedure of 18th century, and it will continue forever. Doctors will remain silent because the judiciary comes anything different. I received the patent, US
That's
patent.
correct. You take your seat, you will feel tired.
I'm sorry.
All of you take your seat, so you will feel tired.
You will be
Yes.
tired.
They can take seat.
Yes, sir, let them sit. You sit and you have to listen because it's very serious.
Here
issue.
there is a
It's a serious issue, sir.
standing. Even the junior stands when the learned senior is arguing. So take your seat, especially in this case.
But it have less to do with custody than to do with world law, not so.
No,
If
sir,
the
it
PI
is the
if-
child.
If the
issue.
PIL has anything to do with this issue.
That I am from the public and it is the child issue.
Say whatever.
And I'm saying
Please
the
better
child is
the-
not a Monday
A
product.
written
Sir.
submission is filed not than these oral submissions.
Child is not a Monday product, sir. If I'm here or anybody, any child, parents are there, mother, father, then only child is born. So mother, father, their mother, father, so they are born. So if you go trace back 400 years, 4,094 people are born, then I am born. I'm not a one-day product. And nobody is born from a dead mother or father. So who made this law? We don't know, but we follow this law. So it is the natural law, medical science law, and it is the child is not a one-day product. It's a million-year living asset of the human generation. So it cannot be, means we know 100-year monument how to protect, but nobody knows how to protect the million-year living asset of the human generation. So this is the basic of it, that you give the custody and the whole society is not educated how to protect this million-year property. They are 18 years is the foundation of their whole life, which is ruined, and you give tears to the children, innocent children. They didn't do anything. So it is injustice. Children say we give our 18 years, and it is the judiciary that is making money. Who is benefited financially?
You are sitting for that green tribunal matter?
Yes.
It will be at 4 o'clock. We will pronounce at 4 o'clock.
I'm ready.
Yes,
So
sorry, madam.
the judiciary is
Sorry for
following.
interruption. Yes.
I'm sorry, sir.
Sorry for interruption.
No, sir. So it is the child is not a one-day product. It is a million-year living asset, and we have to protect it. You follow the man-made law, but we have to follow for our existence the natural law. So we have to protect this million-year property. How to protect it? That is the another remedy part. But the remedy cannot be implemented because they have signed the agreement with the UN Charter. So how these PIL is all waste of time, money and energy, because nobody is able to protect the children so far in 150 years.
This PIL is waste of time, money and energy.
Yes, sir, because we are not able to help the children. This is the proof that I am here to protect the
Oh,
children.
money and energy we don't know, but there is a waste of time.
Yes, sir, it is all because we are not able to help the children. And this is the proof 150 years. All the countries are trying to help the children, but they are not. To traumatize the child is legal, but to help the child is illegal. Then how you will help the child? Because if the child has some problem, the school students, they organize this thing, a meeting with the mother and the son, and then the mother is sent to the jail. Then who will help the child? Child suffer alone. There is no, the children, they say, we die every day. Kill us in one time. How much painful it is for the children. And we are not able to do, because to traumatize the child is legal. Do anything once custody granted means anybody can do anything with the child in the school, events, home, family, and the child has nothing to say. Child is tortured before coming to the court, during the court procedures, afterwards, and lifetime it carries. So you are destroying the whole human generation at the grassroots level. Means the children are the foundation of the human generation. And every day the divorce rate is escalating very high. And the children are suffering. Not only 1 or 2 millions. And this is the medical education issue is the proof that this will continue forever because nobody can crack the UN Charter. So I have given the things. Deadlock between the two laws is the new, never heard before. Then it's a misuse of the power of judiciary because you follow the law. You are paid by the government to give the justice, but the children are suffering. They will continue to suffer because of the ICJ and UN Charter law. Then what you do? So to stop it, only remedy is that the judiciary has the jurisdiction to forward the issue to member state nation that whatever I have filed, you put a cover letter, file it to the member state nation, they will forward it to the UN Charter. I'm a US citizen because I had to get the US patent. Indian patent does not cover the technique claim. So it is intellectual property law issue of the copyright problem. I have the solution with the patent, but it cannot be implemented. And nobody, just like me, scientist, other people might have tried, but they could not come to this stage. But this is how the government will suppress the new knowledge, which public needs it. Public is paying the taxes. Public is paying to the government. Government is paying you. And then the children are suffering. So how many damages are done to the public is a 30 list I have already submitted. Now, education, what is the use of education if you teach wrong things in the school and the colleges? You are training at all the schools.
Yes.
Yes, sir. So it is we want to help the children. We want the foundation, solid foundation of our next generation after 20 years. What kind of children will be produced? What is the development requirement? So that is the whole, another plan is there. But that remedy cannot be implemented because they have signed the agreement with the UN Charter. And those signatories are political people. They don't know neither the law, neither the medicine. So the judiciary has only the power to forward this issue to the member state nation to be forwarded to the chief. Because other way, they cannot take any action. Nobody has a jurisdiction to forward the issue. So unless we crack the UN Charter, now who will crack? Only the chief has the administration, chief of UN. So he has to designate these law scholars so that they will have a jurisdiction to talk about it. Even the Chief Justice, retired Chief Justice of India, 4 people I have talked, they cannot talk about this issue because talking about issue is also illegal. So I had to do all my work all alone without any support because who will support will be illegal and penalized. And it is not a small penalty, 10 lakhs, 10 years of jail, if you talk about it. But I have the jurisdiction because I have the patent. So I have the remedy for both. But even if I give you the remedy, it cannot be implemented. This is the proof. So this is intellectual property law issue of the medical science, and this is the evidence supporting proof that this PIL and this will not work for the legally it will not work for the children, that they will not be protected. So something you have to do with your own exclusive jurisdiction, sir. That is my request. And any questions, I'm here.
Yeah. You are here. So next. 17.
A small submission, my lord. My lord, I have recently filed my wakalat to appear along with Mr. Kiran Kumar for respondent number 3. My name may be reflected in the cause.
Not reflected.
It's not reflected.
Learned advocate Ms. So and so stated that she has filed wakalat now on behalf of respondent 5. 3.
Appear along with
learned advocate Mr.
Kiran Kumar.
It is senior advocate.
No.
Along with learned advocate senior Kiran Kumar, the official reflect the name of the learned advocate while notifying the petition on the next date.
Number 9.
9 also will go to.
Sir?
9 can go to. Let's maybe
I'm
make
done.
it. Pardon. Yes, madam.
The case is over, madam.
Case is over. Okay, so you will give the response. Thank you very much, sir. Appreciate you.
Number 9.
But 9, it is already argued, so we'll keep it on 9. 9th December.
So may be permitted to file IA for deletion of respondent number 8 and 9.
Learned advocate, Mr. So and so and so, for the
Pawan
appellant.
Kumar MN.
Appellant.
Appellant.
Files. Interim application. Interim application.
This is
Are you
matter.
file in the office memo or what? Are you file in the office?
Office minutes, please.
So and so wants to file interim application whereby he seeks to delete respondent number 8 and 9 from the area of the respondents. The IA shall be filed as for the procedure and the registry and shall be listed on 3rd of December for appropriate orders. So on that day will you delete, then means
This matter where my lords indicated,
you file IA, then we'll
please minutes.
deal with it.
Case number 10. Mr. Balakrishna MR.
I'm for the appellants in this matter, my lord. The connected writ appeal number 129/2024 listed on 6/1/2025, my lords. So this case also may be listed on the same
It
day.
is stated that the connected writ appeal number
Writ appeal number 129/2024.
23924 is slated to be listed on
6/1/2025.
of January. This appeal shall also be listed along with on the same date.
In the meantime, notice kindly be issued to the respondents, my lord, with regard to IA number 1/2024. IA number 3/2024, continuation delay. 1 day delay is there, my lord.
On that they will, yes. Then 11,
Much
Seal
of
number
the
11. Seal number 11. Agent seal number 12. Mr. Iremar. Seal number 12.
In this matter relates to two notifications issued by the central government with respect to lockdown period. Lockdown period, there are two notifications issued. Last Friday, heard a similar matter, passed an interim order. This is a connected matter, common order passed by the learned single judge. The interim order passed by this court.
in which
Connected matter.
arising out of same order.
Please, minutes. This is a common order passed by the learned single judge.
So to be listed with writ appeal number 154/24, since the present one also arises out of the very order impugned in the said appeal.
Notice also should do. Notice should go.
We say it will be open for the petitioner to serve a copy of the petition to the counsels who are appearing in the cognate appeal.
The interim order.
Interim order is already operating. You need not.
Different IDs are different. Industrial disputes are different between.
Then we'll hear it, not in that way. Then we hear it on 8th of January.
Short date may be given. 28th of matter is coming up, my lord, before the industrial tribunal.
So then it is already procedure state.
No, this is the ID is different.
Before the tribunal are state, what more do you want?
No, my lords, there are two different IDs, my lord, industrial dispute, my lords. One filed by my lords, other appellant. This appellant industrial
Then
dispute.
we'll hear it first,
Please,
4th of January, 4th of December.
please, my lords.
No order, except 4th of December.
Yes, 4th of December. 13 is agent. Seal number 14. It's a commercial appeal. The Chandini, yes. 14.
For the appellant in this matter, your lordships. Your lordships, this matter arises between the appellant and the appellants were the partners of.
It is returnable on 10th March,
Yes, your lordship.
12th March.
Your lordships, we need a stay, your lordships, in this
Then you
matter.
deposit the amount.
It has been deposited, sir.
Where is that?
We've paid the court fee.
No, amount you deposit, decretal amount. There is not a court fee.
Let the matter be passed over. I'll confirm
No,
with the
no passing
senior.
over is not possible.
We have actually paid the requisite court fee and also the deposit, 20% mandatory deposit.
It will go to then 29th of November, sir. Next. There is no possible, it is not possible to pass over any matter. Next.
29. One more notice.
15 adjourned.
15 adjourned, seal number 16. Satyananda BS.
Now the 16 was not available for reading. What is the proof matter?
Earlier, my lord, 6th was the date given.
Lordships had given date of 6th for orders.
That is.
This is a matter, my lord,
May, Lordships, may I address you? Your Lordships, may I address you?
One second.
Yes, Your Lord.
Yes.
this is a
was
matter, my lord,
kept
which
on
your lordships.
4th, but this is kept today for reserved for orders.
My lord, what I have done is, my lord, in the meantime, I have filed an application, my lord. IA number 3 is listed tagged along with this particular petition.
What is it, IA?
My lord, this IA, my lord, under this IA, my lord, I am seeking permission of your lordships to amend the grounds raised in the commercial application, my lord. For this reason, my lord, a general ground, I just went through the entire grounds, my lord, which has been raised by us. General ground of patent illegality and, my lord, opposed to law is taken. My lord, specifically, my lord, the amount what I had paid to them, my lord, was not raised. That is where, my lord, out of inadvertence, my lord, such a thing has happened.
May,
That is where, my lord, if my lords may permit me, my lord, I'll amend the.
may I now address your Lordships?
Lord.
Let's get some case law set for your lordships, please.
Lord, I can only say this much, my lord. Before the commercial court under section 34, my lord, I had specifically at paragraph number 27 had made it very.
Seeking some amendment, it can be allowed in ground. Mr. Counsel from Bombay.
Yes, your Lordships.
He is seeking some amendment in the ground only, so it can be allowed.
Your Lordships, may I? This is something which is on the verge of being ridiculous, your Lordship. Section 34, which has already been decided, and now he wants to amend the grounds. Tomorrow he will say that SOD also should be allowed to be amended.
No, it is not that.
And in the ground has to be allowed. IA is there today?
IA is there, my lord.
IA is allowed.
My lord, then, my lord, in that event, my lord, the records pertaining to commercial application, my lord, requires to be secured.
You are seeking amendment?
Amendment of commercial application.
Then, no, there is no question.
My lord, I submit like this.
I thought that you are going to amend the ground here.
No, reason is, my lord, it's an appeal, my lord.
Then,
appeal is nothing but continuation of the original proceedings. But nonetheless, my lord, there was.
Hence, your Lordships, I use the word
Lord,
that.
So we are, in fact, it was heard and we are now reserving. Today it was kept preponed because we wanted to reserve the order. Instead of.
My lord, may I make one submission, my lord? May I bring to your Lordship's notice, my lord, this judgment of this court, my lord, which I had produced on the last date of hearing. Lords may kindly see this judgment, my lord, for a minute.
Well, your Lordships, I just.
Two judgments. Lord, two judgments were placed before your Lordships on the last date. Lords may request my lords to kindly see that particular judgment as to what is the duty, my lord, of 34 court. Lord, this is what this court, my lord, has held in Warsa's case. Lord, may I request your Lordships, my lord.
I think you showed that last week.
Yes, I showed to your Lordships, but I did not highlight on this aspect.
Where is that judgment?
Lord, two judgments have been placed before your Lordships, my lord. Kindly see one of Supreme Court judgment, my lord, which is reported in
If you are arguing again, then we may ask the counsel from Bombay to come and submit.
My lord, these two judgments, I'll place it on record. I have
he's-
already placed it on record. One. Secondly,
I
my
think
lord,
my learned friend has completely taken it on a different, he's asking for the commercial application in section 34, which was before the learned additional.
That we are not entertaining.
my lord, I only say this much, my lord.
We thought that
May
we
I,
were
may I
amending
make
ground
this?
here.
No, may I make this submission, my lord? My lord, section 34, I had raised these grounds. One of the contentions raised by the other side, my lord, is that specific grounds, my lord, was not raised.
Heard learned, this is a group of people.
Please, my lord, all the
Learned advocate, Mr. So-and-so. For the appellants in all the appellants, come a learned senior advocate. Your senior advocate, Mr.
Not designated yet.
You have put us in dilemma.
Yeah, probably your lordships have looked at my hair and finding them to be white.
Unfortunately, we can't designate.
No, your lordships can definitely.
No. And learned advocate Ms. Kamlesh Gaure, who appeared to raise submissions physically as well as through video conferencing, assisted by learned advocate so-and-so at length. Learned counsel for the party stated that I argued the applications finally. They further stated that the pleadings are complete and no further are required to be added or supplemented, reserved for judgment.
Please,
Lord,
pass on a
interim-
compilation of judgments on scope of section 37.
I can only, my lord, say this.
We'll
These
consider
two
all.
judgments, my lord, I am only requesting your lordships, my lord, to consider my case insofar as double pay, my lord. If this writ petition, if this commercial appeals, my lord, requires to be thrown out, my lord, I'll be curtains down. That's the reason, my lord, I am before your lordships now. It amounts to double payment.
It
Lord,
does not-
unnecessarily, whatever payment has been made by me, my lord, has not been accounted by the
There
learned
is- there is
arbitrator
no-
also. That
there
is
is
where,
no-
my lord, I am only making a submission to your lordships through this application. Permit me, my lord, to raise appropriate grounds. It's a fit case, my lord, for remand, because learned arbitrator, my lord, has not considered this.
My learned friend is making some very fallacious statements.
It is not fallacious statement. It is a correct statement which
It
I am
is
making.
not
Let
at
us
all.
not take it like that.
So, Mr. Counsel, we will consider your case, the
Yes.
case of the other side and our case also.
Yeah.
Two judgments, my lord, I have placed it on record. It says that,
Reserved for judgment. No point in now debating. Yes.
my lord,
It is
interim order, my lord, request to be extended. Whatever undertaking they had given to your lordships.
Yes.
That is
Good.
getting extended from time to time.
Once it is reserved, it is reserved. Everything continues till
Please,
we pronounce.
Please,
the judgment.
please.
Oblige all. And I'm grateful that your lordship thought that I was a senior advocate designated. Maybe I'll increase some briefs over there. Obliged.
Syllabus 17. Sharath says Gowda.
Yes, what is it?
My lords. For the complaint, my lords, please pass over, my lords.
Pass over not possible. January 8.
My lords, it was listed twice, my lords. It didn't reach, my lords. This is the first time it's reaching.
See what are the direction then? You argue then. Simple contempt matter.
That's,
My lord,
we have filed
this
our
is with
compliance
respect-
report, my lords.
You filed.
My lords, there is a direction to the effect that Podi and Durasti has to be conducted. My lords, here we have gone to do the spot inspection and initiated the survey and Podi Durasti work. But there was lot of objections from the public, general public, villagers, and therefore we are not in a position to conduct the Podi and Durasti. And therefore an endorsement has been issued, my lords. My own respectful submission is there is no willful disobedience of the order.
Why you could not conduct this?
Lords, here we have Mahajar has been drawn. The villagers did not permit us to conduct the survey, my lords. Lordship, may kindly see page, paragraph 3 of the compliance affidavit.
Which is the property?
The property is with respect to 31 of Fodige Halli, Yeshwantpura Hobli. several properties, my lords.
My lords, we had given a representation to the.
You go with police protection, very.
Please,
You go with police protection and conduct the 14.
lords, I'll file a better affidavit, my lords. Your lordship may grant me 8 weeks' time.
It is no ground that the villages are not permitting. To go with the police protection.
Please.
January.
Please,
Seek police protection and go again.
please.
Number 18.
For the petitioner in this matter, my lords, I seek for an accommodation since Mr. Dhyan Chinnappa is appearing in this matter, senior counsel.
17.
Serial number 18, my lords. He's on his feet before another court. My lords may have it after vacations, my lord, any date, maybe next.
18 is 2007 petition. Nothing will survive.
Yes, my lords.
We say infectious because of a flux of time.
No, my lords. He has to make certain submissions.
Who?
Senior counsel, Mr. Dhyan Chinnappa is appearing in this matter.
We'll take up on 6th of December.
After vacations, my lord.
2007 petition.
Great. 6 December.
15 years ago.
This honorable court had directed the registrar to conduct an inquiry, my lords, as regards the cooperative society. An inquiry has also been conducted and it is placed before your lordships, my lords. Now it has to proceed in accordance with the provisions of the Cooperative Societies Act, my lords. It's a full, complete, all the provisions are to be.
9th of November, 9th of December we are keeping. To be listed at 9th of November, on 9th of November at 2:30. Since prima facie the petition has become infectious because of a flux of time.
9th of November. 9th of November, my lord.
9th of December.
December.
Will on that day we will not grant time.
Great.
Yes.
Public.
Great. Is still number 19. For the response.
19 is, notice is this. 19 is first time.
I filed 2 applications, my lords, for recall of the order.
Restore this. So order in IA number 3 of 24 and with IA number 2 of 24. All learned with parties and subtitle I order in IA number 3 of 24. The present application is filed, trying to condone the delay of 21 days, which has taken place in filing the application for restoration of the appeal. In order to enable the appellant to contest the case on merits and in view of the amendments made in the application, explaining the passage of time, leading to delay of 21 days, as sufficient cause is made out, the delay is condoned, full stop, this application is allowed. Order in IA number 2 of 24. It appears that by virtue of order dated 3/6/24, the writ appeal stood dismissed for want of prosecution. The present application is filed with a prayer to restore the appeal in order to enable the appellant to contest his case on merits. The application is allowed by restoring the appeal number, writ appeal number 712 of 24 to its original files, along with the orders which may be subsisting therein. Application is allowed accordingly.
My lords, the permanent obstruction is caused to the staircase of my residential house, my lord. It is causing a huge convenience. The learned single judge has called for the report from the commissioner, the PDO, he has inspected the spot. There is absolutely no scope for interference, my lord. It is, my lord, the learned single has assigned the well-assigned reasons. Because it's my residential house, my lord. He has put up a permanent blockade, my lord, without obtaining the license. And the report is called for by the learned single judge. The report is secured. And after considering that report, my lord, it was observed that it was a permanent obstruction is bad to deny my access to reach my residential house, my lord. So such report is available. Learned single judge assigned all well reasons. If he is having any individual right or he claims that it is his own property, the learned single judge just stated that he has to approach the civil court. Kindly look at paragraph number 2, my lord.
We'll consider when the appeal is taken.
Please.
Interim
order may kindly be. Interim order may kindly be extended.
Because
interim order, my lords, there is an interim order of status quo.
My access denial is early.
Respondent number 3 is claiming access through my property, my lords. He wants to use my stairs to go to his house.
We'll extend, stand over to, order in appeal now. Stand over to which date?
Hello, next month.
Next month. Give some date.
Early date, my lord. Because my house is there, my lord. I have been denied access.
My lords, he has a separate access from the main road, my lords. Both are brothers. He wants to use my stairs to go to his property.
16th December.
Grateful, my lords.
Interim orders shall continue to operate till the next day.
Meanwhile, I'll comply with the 3 office objections, my lords, which were not great.
My lord, with regard to the respondent number 1 and 2, my lord, Mr. Panic also, Mr. Ashok Naik may be director to appeal.
They have already entered.
Please.
Great.
This number 20. Mr. Sagar Bibi.
Lordship, may kindly permit me to withdraw the contempt, my lords. It's
Learned
endorsement
Sagar
of the issue.
seeks permission to withdraw the contempt petition by filing memo dated so and so, which is taken on record. Memo dated 26 November 24. Dismissed as withdrawn.
Obliged.
Number 21. Vasant Kumar K.
21, my lord, I would like to file my compliance affidavit.
Yeah, just now served a copy of this, my lord. It runs to 30 pages, larger than the contempt. Counter is larger. I required some time, my lord, I'll reply.
I've just narrated, it's an interim order on which the contempt has been
that
brought
your
about.
lordships already heard on the last occasion, my lord. Your lordship wanted to know what she has done. She has served copy just now, my lord. On 9th, my lord, other matters are coming up. Your lordship may have it, my lord, I'll argue. 9th of December.
Compliance affidavit.
So page 18 is the order.
Please, my lord.
Page 18 is the order.
Please, page 18 is the order.
Yeah, just now served, my lord, set of documents. It runs to 30 pages, my lord. I'm not able to
16.
guess what.
Sorry, page 16.
Page 16 is the order.
16, annexure A. The interim order is dated 11 September 23. In my affidavit, I have just narrated as to what has transpired and how the issue of
My lord, kindly see your lordship's order passed on the last occasion, my lord. Your lordship heard the matter at length, my lord. Then asked her to file detailed affidavit to what she has done in that regard. That is why she has just now, my lord, filing.
what is relevant in my affidavit, my lord, is para 5 and para 11. As per the Forest Act and rules, the authorities have acted, and also as per the previous writ petition order, which says that if the complainant appears to be an encroacher, then take action in accordance with law. I have extracted the relevant portion of the previous order after para 7, my lord. And para 11, I have stated that the eviction, which is a summary eviction under section 64A of the Karnataka Forest Act, and the possession was taken before the interim order obtained,
Yes, no copies, sir. 2 minutes back, just to put it to my colleague.
Nothing to be read except paragraph 13. Don't read anything. We'll read together. I humbly state that I read for your kind consideration.
My request is, my lord, just no copies. Let you put, my lord, counter on.
We are reading together.
Advocate on record, my lord, there has to be, my lord.
We are reading together.
No, I'm not for a moment taking adjournment for sake, my lord. I just want to try to do it, my lord. On the last day, your lordship heard the matter. Said on the last second, your lordship kindly see the order. Matter was heard at length. It's not as if, my lord, by endorsement possible. Your lordship said put in writing. My lord, 30 pages, just right now, 2 minutes back here. I will just short accommodation.
So 30 pages.
Short accommodation, I will be, my lord. Forget, my lord, 30 pages. Let my, my lord, counterpart.
Paragraph 13.
Very good. Very good.
You read it.
Which one?
Paragraph 13.
My lord, kindly see the first order, my lord. I'll be able to demonstrate how it is, my lord. May I, my lord? May I
Totally
first-
frivolous petition you are bringing.
My lord, may I, my lord?
Suppressing everything before the court and opening order and then filing contempt.
My lord,
See, read it,
that is
paragraph
not the
13.
case, my lord. Kindly see the.
It is, Mr. Counsel.
Yes, my lord. Page 18 is the
Sir,
first
you
order.
would really grant the time.
Kindly see page 18, my lord, of the interim order. I'll be able to demonstrate, my lord. Ultimately, I will.
We are demonstrating paragraph 13 before you read it.
Yes.
Please read it.
Which one?
What we direct you to do in the court of law.
Which one?
Paragraph 13 of the reply.
Yes.
Don't indulge into
I'll-
debate. Once we say.
Para 13, my lord.
Yes, read it.
Yes, I'll do. Para 13. I humbly state that immediately thereafter, complaint hearing has again approached the honorable court in WP number so and so, seeking an interim order, directing the respondents herein not to take coercive steps for eviction against the complainant from the scheduled property in question, though the eviction proceedings and measure had already been conducted and possession taken by the first accused so and so itself, as mentioned above. I state that this aspect was suppressed by the complainant while obtaining interim order. Hence, there is no violation of non-compliance of the respondent authorities accused herein to the orders of this honorable court. I humbly state the respondent authorities in due compliance of the orders of the court and the provisions and procedures detailed in Karnataka Forest Act and rules have issued notice, conducted joint survey, and then evicted the complaint and taken possession of scheduled property, which is enclosed forest land notified as Srinivaspura State Forest as per notification. So and so. This is the complaint.
You had encroached the earlier forest land.
Yes.
Earlier litigation was filed. The possession was already taken over. You again filed.
My lord, that was done under pressure. My.
Again filed the petition, suppress the fact and got the order, and now we are filing contempt petition.
No, I will demonstrate. The only thing is, if under pressure, if they take letters like that, because on the last occasion they did not say this, my lord. Kindly see page 18. I will do my best. Page 18 of the paper.
Sorry.
Page 18 of the papers.
There are 280 grounds as to why this court will not entertain the present public interest, present contempt petition. First is that the order dated 11/9/2023, which is.
Kindly give me an opportunity to argue for 2 minutes at least. I'll be.
No, we are not.
Two orders, my lord. Two orders.
On the ground that this is interim order, we are not entertaining.
Lord, that your lordship's matter has been taken. Supreme Court, I write to your lordship, Lord. Supreme Court has passed an order, my lord, staying your lordship's order.
We'll deal with the merit also.
No, yes, I have filed it. I have filed it. No, with great respect, my submission.
Counsel is non-cooperative, adjourn sine die.
Next week at least, Lord, can I? I'm sorry, next week can I request, Lord, at least? Or right now I'll argue with that.
Can't be cooperative, Mr. Counsel, non-cooperative. When we are saying there is nothing in the matter.
Then I will argue. You will actually take it.
No, we will not take up now, today.
Next week at least possible.
We will not take up next week.
On 9th,
go to 10th
of March. On 9th of March.
Mr. Counsel, you are just wasting the court's time by filing frivolous
I'm sorry.
hopeless contempt petition.
Ninth, my lord, I think.
When you are already evicted while filing the petition,
Such papers are. my
took
lord.
order suppressing the fact, now you are filing contempt that you are.
I wanted to demonstrate at least, my lord. Ninth, I think other.
Already
matters are-
seen the things.
Ninth, other matters are coming up on ninth. Would it be?
No
ninth
other
at
matter.
least?
This is the only matter. We look at it. 10th of March.
My lord, March moved too long a period.
So when do you want?
9th of December, other matters. Anyway, I will, all other matters.
So
can
you
similar-
go on dictating the court.
I am not only requesting the court, my lord.
We don't like the dictation to the court. Courts are not meant to be dictated.
Right. now,
Courts
I'm
are meant to
going
be
argue, but
argued
thing
and
is, my lord,
submitted.
no, right now, the copy is supplied was my only submission.
It is too much, Mr. Counsel. We are saying that there is a hopeless petition. And we have demonstrated by making you read the paragraph. You have suppressed the thing, filed a petition,
Right now,
obtained an order,
No,
where the
one order-
possession already taken up,
Right.
obtain an order not to dispossess, when the possession was already taken up,
That
and
was
now you
not
are
there.
filing contempt
Under
petition.
pressure, they have got it done. Earlier order was there, I wanted to say. Two orders are there.
29th of November, sir.
Great.
Much.
So
Great.
number 22. So
Thoroughly
Praveen,
waste of time, Mr. Counsel.
HP.
For the complainant, but
Yes, what is this?
Lordships are directed at the last
That's
occasion.
some interest part.
Yes, ma'am, the
Interest part
interest.
remains.
Yes, ma'am. So in fact, I just submit an affidavit. I'll take my lords directly, although it's slightly more verbose affidavit than required. Also, my lords, for the simplicity of this, the issue, I've prepared a small chart, my lords, just to show that there is already an element of interest. I'll just point it out. My lords, would to kindly come to the chart itself. This is basically a simplification of what we have said at paragraph 10.
Paragraph.
Paragraph 10 of our, I think, the affidavit just filed. But this, before that, could I request my lords to go to the chart, because that is basically a tabulation of what we've said in para 10.
yes, I will file my rejoinder to this, my lords. Apart from that, I want to draw my lord's attention to two things, my lords. They have acquired, my lords, and paid compensation for my land for 68.5 square meters of land, my lords. However, they are paying me for the acquisition of 51 square meters of land. That is also not in accordance with. If at all, I may draw my lord's attention to their own affidavit filed today. My lords may kindly see. They say, my lords, 50 square meters of petitioner's land was acquired and paid compensation to Sujata Vijay. And 18.5 square meters of petitioner's land was acquired and compensation was paid to Bindu Raheja. Total, my lords, is 68.5 square meters. However, my lords, they are paying me compensation for 51 square meters. And they are saying, my lords, it is in compliance with the order.
How much total?
Well, 68.5 square meters as per their own affidavit, my lords.
They are paying for towards?
51 square meters. How can it be, my lords, compliance? Their admission is there.
Getting into the maths, I can point it out, my lords. 371 square meters, they got 9 odd crores back in 2018. That's why if I could request my lords to kindly see that table. 371 square meters, not an issue. The table I just handed across. my lord.
Where is that entire paragraph you explained, page?
Paragraph 10, my lords, of the affidavit we just filed.
You file now? Yes. So you'll be paying 179 for it?
Yes, that will deposit. my lord. That we
Addition.
will give it.
Malas, may I draw my lord's attention to paragraph 5 of the affidavit, Malas?
Paragraph?
Paragraph 5 of the reply.
Petition.
Today, para 5
Of this,
of affidavit filed today, Malas.
yes, read.
Malas, may kindly see the last line, Malas, at the bottom of the page. Malas, wherein they have admitted, Malas, the 50 square meters of land, compensation for acquisition of complainant's 50 square meters of land, Malas, has been paid to Vijaya, Sujata Vijay. In para 6, Malas, last 3 lines of the paragraph may kindly be seen, wherein it is admitted that the said Srimati Bindu Raija is still due to return rupees 49,90,853 pertaining to the remaining 18.5 square meters beer through her advocate at Bangalore. Affidavit, Malas, filed before this honorable court and this reply affidavit. They have admitted, Malas, the petitioner's land, Malas, measuring 68.5 square meters has
What you
been
have to
acquired
say?
and compensation paid to somebody else.
Says that even this calculation.
That is somebody else's land also, my lord. So as insofar as the complainant's land is concerned, 500 square meters was what is actually utilized. That may cover some of the compensation given to these two ladies, and also, my lord, the comp to these two ladies also covers another person's land. But to keep it very simple, 371 square meters, no dispute. Compensation was given way back in 2018. 371. Now, 500 is what is utilized. Difference is 129. And insofar as 78 square meters, again, 2018 itself was collected from one of the two ladies and given to the complainant. That what remains is 51 square meters, for which now we have given the compensation, including the interest at bank rate.
Malas, it is not accurate statement, Malas, because the statement of objection filed before the red court, Malas, they have admitted that around 8.5 square meters of land has not been utilized.
May I say this?
Now,
this is a
Malas,
classic case of the complainant getting greedy. He knew his land was notified twice over. I didn't want to go that far, but since my learned friend is pushing, not.
Malas, my land has been notified, Malas, possession notice has been issued. My title, Malas, is hanging because of the negligence. Malas, I am left with no option, Malas, I cannot even use the land because my title is not perfect because of their mistake. Now, Malas, they don't want to pay compensation, they don't want to pay interest on the said compensation amount also, Malas. As per the orders of this court, Malas, and the Supreme Court, Malas, 15% interest has to be paid on the total package that they are not ready to pay. Also, I will file my rejoinder, my lords, to this reply affidavit. And reply affidavit, my lords, is not filed by the accused. It is filed by some other officer.
You pulled him out of retirement. Just like how you disappeared last time, no? The matter was called up.
For orders for.
Also, I may be given the liberty to exercise my rights, my lords, which
Will consider.
please, please.
Number 23.
Lord, I am the petitioner.
Ravi Shankar.
The respondents were to file a written statement of objections, which they have not filed.
Yes, in this case, I appear for respondent number 1, Archaeological Survey of India minutes. I have received instructions. I seek for little time to place and record the.
What is it?
This is pertaining to direction of conducting an archaeological survey at Sri Rangapatana Jamia Masjid. This is in reference to section 21, 22, 23 and section 35A of Ancient Monument and Archaeological Sites and Remains Act.
One time.
As against section 16, my lord. It's being misused as a madrasa.
No,
My lord,
the-
similar matter, writ petition 710 of
relief chart-
2024.
It is different.
Relief
Not
chart
same pertaining to the same.
masjid.
It is what we are.
Yes, sir.
Yes. My
Relief
lord
chart in
may
that
see-
petition and
My lord, it is politically motivated. My lord may see the description of the petitioner.
The petitioner himself is not a politician, my lord. We are not, and it's non-political organization, absolutely.
may I make submission? Sir? Relief chart in that writ petition is illegal madrasa being run in a monument manner. Here, relief chart is little different.
Yes.
But one relief covers the relief already there in the writ petition.
So we both will keep together.
My lord, I
Maybe-
take notice for respondents, my lord, 2, 5 and 6. My lord, please take the notice that is issued, my lord, which is that page. Page 67. Legal notice. My lord, and please take page 76. My lord, may take that paragraph with above submissions.
Page.
Page 76. My lord, it is a legal notice which is at page 67. My lord may take, my lord, page 76. With the above submissions.
No.
Lord, submissions are made. My lord, it is, may I be permitted to read, my lord? It is now necessary for above addressees adopt corrective time-bound measures from their committed wrongs, corrective measures such as carrying out archaeological survey, videographing herein referred age-old temple, now called disputed masjid of the subject matter and reference. My lord, page 76. My lord, annexure C, C1. Page 67,
I
page
think
C1.
it is between 80 and 89.
This is the copy that he gives me, my lord. Page is annexure C1.
C1.
My lord, according to me, my lord, it is page, my lord, the last but one page of that legal notice, my lord.
Yes.
My lord, after paragraph 20, bottom. My lord, with above submission, my lord gets it.
Yes.
It is now necessary for above addressees adopt corrective time-bound measures from their measures such as carrying out archaeological survey, videographing herein referred age-old temple now called disputed masjid of the subject matter and reference. This notice calls for initiating necessary legal action as may be necessary by the above addressees parties in their combined and or respective authority to rectify, correct said historical blunder, thereby respect the Constitution of India and to take necessary measures to respectfully use in order to secure unity in diversity and in its binding constitution. It is hereby submitted that all the above are informed to reply legislative and parliament willful continued violation of true democratic ideals that
File revision application, so rule 53.
53, my lord.
Rule 53, my lords, but there is a clear violation of principles of natural justice.
What is very?
That's the reason. My lords, I'm not given an opportunity of her hearing before the passing of this notice. My lords, I have not excavated the minerals at all, my lords. There was no lease subsisting as on that date, my lords. They're demanding for the year during 2017 to 23, my lords. There was no lease at all, my lords.
They are not heard.
My lord, my lord may see my paragraph 5 of the writ petition, my lord. They have suppressed facts that an earlier demand notice has been issued. My lord, suppressing that fact, they get the lease renewed. Paragraph 5, internal page 3.
Internal page.
3, my lord, of my statement of objections.
My lords, may I draw my lord's attention to page number 39, it's only one paragraph. Senior geologist himself has filed a report saying that there is no royalty due. I'll read only that paragraph. Page number 39, months. He has filed a report, my lords, before the respondent number 2. Page number 39, last paragraph. As per the audit of the year 2008 to 9, 500 M10 was extracted in the said area. As per the audit of the year 2009 to 10, 600 M10 mineral was extracted, and in the year 2010 to 11, 4 M10 mineral was extracted. In all, royalty has been paid for the 1,500 million ton mineral. While verifying earlier audit reports pertaining to the stone quarrying lease, it is found that a sum of rupees 45,000 has been paid for total 1,500 M10 towards royalty. He himself has filed a report, my lords, that there is no royalty due. And again, demanding notice is not sustainable, my lords.
take this as a, and record all. This implements as a show as and file adjudicated into. For orders on sixth.
Great.
Number 26, Jayasima KP.
Nobody is there. What is it about?
There's an issue on environmental compensation.
After vacation, 10th January.
Number 27.
I appear for the petition.
My lord, in this I pray for some time, my lord, serial number 27.
4th February.
Number 28. Shivalli.
Petition. The petitioner not challenging the notice dated 3rd December 2024. Sorry. 3rd January 2024. Where under not the competent authority is demanding rupees 3 crore 85 lakhs 13,650. This is a demand notice not has been issued straight away without conducting not inquiry or without providing an opportunity of hearing, and that there is a gross violation of principles of natural justice.
इसमें notice नहीं है.
My lord, a statement of objections has also been filed on 13th March 2024. My lord, along with the statement of objections at annexure R5, we have produced the notice, fresh notice that has been issued on 5th of March 2024, which has not been challenged by the petitioners so far.
I'm sorry that statement of objection not served on.
Very well.
I know.
Learned additional education. Ms. Srimati Nilofer shall serve copy of the statement of objections. Within 2 days, send out.
My lord, I have already served it, my lord.
Has served today the copy of statement of objections to the counsel for the petitioner, send over to go to December, not December, February. 5th February.
Number 29.
I-
Nayak NR.
I beg to appear for a petitioner, my lord. In these two cases, 29 and 30, my lord, both of them, they have made an application for grant of quarry of lease, my lord.
Reply shall be.
My lord, endorsement has been issued considering their application. My lord may have this next week, my lord. I'll serve it on them and file it in the office.
Please.
Send over to 11th December. Within which time the reply shall be served on the petitioner.
December 30. December 31. Mr. Ganpati Bhatt, 31.
Right.
December 31, Mr. Ganpati Bhatt.
My lord, in this also I have filed my statement of objections on 8th of July, my lord.
Learned advocate for the petitioner is not present in that you send over to 4th February. Not 4th, earlier. 17th December. Interim orders granted arrears continue to operate till the next.
December 32.
Oh, I appear.
Lochana Babu.
What is the PA? On page. ಇದಾ? We'll take up.
My lord, I'll file a memo also. Yes, my lord may grant me some time because we.
9th January.
Tribunal is not functioning at all, my lord. Vacancies are there. And the 3 circuit benches are also there, 2 circuit benches.
We'll see.
Completely vacant.
33. Mr. Srinivas Rao, CN.
For the appellant, my lords, on 33.1, please, my lord. The matter pertains to, my lords, the recruitment to the post of assistant engineer, my lords, electrical in KPTCL, please, my lord.
Lordship, in this matter, I appear in 33.4. The examination was conducted, some mistakes took place therein. In the key. It has to be heard, your lordship. It has to be heard.
Or, so when shall we heard?
Lordship, at the earliest.
Tell the date and we'll keep it. Any date.
Any date is good. Which date? December itself, 11th or 12th.
17.
At 2:30, if your lordships please, man. At 2:30, if your lordships may kindly fix.
17.
It could be had at 2:30.
That we'll see on that.
Number 34. Mr. Krishna S. Vyas.
I'm appearing for the respondent number 2 and 3, my lordship.
That's seemingly my counsel on the
Small
other side.
accommodation I need. My senior counsel is out of station.
Fine. You want
I'm kindly I have this matter December 10th. December 10th.
10th January.
Interim order be extended, my lords. Interim order be.
Number 35. Srimati Ashwini. Number
I
35.
appear.
For respondent. Give it to
This matter, my lord. The appellant has received, the appellant is the university, my lord. The respondent has received benefits and has sought benefits and is seeking to attend the assistance class.
Lords, may I
Although
request
is
to
not
pass over?
entitled.
Pass over, my lord, senior.
Pass.
Please.
Number 36.
Here for the petitioner's counsel,
Vivek Kolla.
appellant's counsel, my lord. What has happened is, sorry.
The point is. It is.
ಅದನ್ನೆಲ್ಲ ನಮ್ಮ ಮಾಡಿ ಹಾಕ್ಬೇಕು. English translation.
This can be heard after some time.
All right, as your lordship.
17th December.
37 is urgent. Still number 38.
Please.
TSP total.
I appear for the
38.
respondent number 2 and 3, my lord. I had been informed the appellate counsel if the matter could be taken up, my lord, if an adjournment could be granted.
Excellent, my lords.
Sir, you are not audible clearly, sir.
My lord, I intimated the appellant's counsel if the matter we are seeking for an adjournment, I appear for respondent number 2 and 3. My lord, if I am audible.
Let it go to some other. January 6th.
My request, my lords, is that any possible short date, my lords,
Short
in this matter,
When do you want?
next week or after 10 days, my lords.
Next. Next.
Number 39. The Deepak Bhaskar.
Yes, for the appellant, my lord. The argument counsel is unless for a short time.
January.
I request that the interim order takes interim.
December may not be possible.
My lords, I request.
January. Some date in January.
T41. Up to 41.
So 41.
Number
I request the appellant.
42. MC Basuraj. Number 42. Number 42, Mr. MC Basuraj. With HR Renuka. Forty-two.
After the
Number 43. Mr. Chetan AC.
Lord, this land was reserved for Toby Ghat, my lord. But actually the 7th respondent is constructing on that.
There is a delay of 10 days notice. Notice written.
All parties are served.
Served. Who appears? Then wait then. Next, keep back.
Yes. Number 44. Mr. Rakesh Kini. 44 Rakesh Kini.
Appearing for respondent number 1.
He is not. Here.
Number 45. Sunita Srinivas.
Appearing for opinion. 2 weeks' time may be granted after that.
My lord, stay petition is coming up for hearing.
My lord,
Your lordships usually pass a stay petition is coming up for hearing. Their stay petition.
there is an interim order, my lord, not to precipitate.
But that is the reason why they are
Same
seeking
may be
adjournment
extended.
after.
Please.
Next.
Short date, man.
Number
Date
40.
is- Where will given? January.
46.
40.
46.
For the appellant.
Vivi
my-
Nidhishri.
My lord, this is section 34 petition that has been allowed and it has been modified, in fact. There was an arbitral award in favor of the appellate. It was a unanimous arbitral award. Now, the section 34 court, in violation of settled law, has set aside certain aspects of the arbitral award by going into the evidence and has conducted out a detailed reappreciation of evidence which is not permissible under section 34, my lord. Matter requires consideration.
So appeal is admitted. To be listed for final hearing the week beginning from 7th April.
My lord, could it be taken up in the regular course, my lord? It's a short point.
Then we'll take up after then February 3.
First week of January, any date convenient to the court?
First week of January, 9th January.
Deeply obliged.
This is about 47.
Hearing for the
Nursing
response.
Murthy K.
My lord, we had filed our compliance affidavit on 19 June 24. This matter, my lord, what has happened is, though the direction of the learned single judge is to consider the request and enter the name of the complainant in the revenue records. What has happened in this case, my lord, the KIADB has acquired these lands in the year 2019. And therefore, the revenue entries to mutate her name, my lord, the question of compensation would arise only. And therefore, we have written to the KIADB on 10/6/24, my lord, if an annexure R2 at page 11 may be looked at for a moment of our compliance affidavit.
My lord, unless, my lord, my name is found in the records of rights, my lord, I am not entitled to get the compensation. Otherwise, my lord, your lordship may kindly direct the KADB to pay me the compensation.
We,
As
for
per
a
the
moment, if your lordship sees
endorsement
the
dated
R2,
10/6/2024.
R2,
My lord, in
my,
page 11, on 10/6/2024, my lord, the accused has written a letter to the special land acquisition officer to pay compensation. But my lord, if I go there, my lord, they say your name should be found in the records of rights. Your name should be found in the records of rights. My lord, they say, my lord, they are unable to enter because it is been acquired. My lord, acquisition is on column number 11 of the records of rights. I will come in the column number 9 of the records of rights. My lord, my name is entered in column number 9 of the record of rights, showing that it has been acquired by the KADB. Then I will get it. Otherwise, my lord, your lordship may kindly direct the KADB to give me compensation as per the law.
my only submission is, has the complainant forwarded this representation that we have given to the, what is it? Allah, because we have in fact written to the special land acquisition officer. My lord, we have written to the special land acquisition officer stating that the Saguli cheat and the records are genuine. So based on this, he can obtain the compensation. Because now the complainant is actually the wife or the daughter-in-law. 1 minute. Is the daughter-in-law of Dasi Gowda. That is the original landholder. So my lord, with this representation that we have given to the land acquisition officer, an order may be passed. The original
letter, my lord, they
landowner
say
died,
that
the son has died and the wife. So this is the
grant is
daughter-in-law.
genuine. There is a Sagoli cheat, everything they admit. But my name is not found in the records of rights. That is the reason, my lord, I filed the writ petition. There is a direction to the Tahsildar to enter my name in the records of rights. Now, my lord, they say. Lord, Lordship may kindly direct the KADB to pay me compensation. That is enough.
We pass the orders for orders on 6th.
This is the daughter-in-law, my lord, so this. Much obliged.
For orders.
47.
My lord, in the next matter, I require some time to get my instructions in order.
Number 48.
I require some time, my lord, in this matter.
January
Much obliged.
17.
Much obliged. Forty-nine compliance is done, my lord.
49 is
Compliance is done.
compliance done. You are 49. You are 49. He says complaint.
Compliance ಮಾಡಿದೆ ನೋಡಿ 10 ಅಂಕನಾಸ್ಗೆ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿದೆ.
That's one intelligence, madam. Serial number 51. There is no contempt, madam. Still, I have felt the reply. He alleged that there is an interim order.
Let it reach. When is it? We'll assemble at 3 o'clock.
ಯಾರು ಮಾತಾಡ್ತಾರಲ್ಲ ಸರ್, ಧಾರವಾಡ ಬೆಂಚಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಯಾರಿದ್ದೀರಾ?
ಸರ್ ನಾನು ವಿಜಯಲಕ್ಷ್ಮಿ ಅಂತ.
ಧಾರವಾಡ ಬೆಂಚಲ್ಲ
ಹಾ ಸರ್.
ಸಾಹೇಬ್ರು ಬಂದಿದ್ದಾರಾ?
ಹಾ ಬಂದ್ರಿ ಸರ್.
ಓಕೆ. Writ appeal 323 of 2024.
Appealing for
Sahib,
Supreme Court disposed of the writ petition, granting liberty to the petitioner to challenge the order dated 22/24 produced by the respondent when the case was listed for admission, my lord. Therefore, that liberty,
Which order?
my lord, on
Dated?
6/3/2024, my lord, writ appeal was
Date. Which is the date?
22/24, my lord. This order was permitted me to challenge it.
Order dated 22/24, which is sought to be challenged in the dispose of petition, constitutes a fresh cause of action. Therefore, the prayer in this application cannot be granted. However, liberty is reserved.
Already filed a writ petition.
Liberty is reserved for the petitioner to institute independent challenge and make all the prayers therein.
Writ petition has already been filed. They have already filed a writ petition.
Then where is the question?
When I filed writ petition, their my lord, their lordship clarified to get the clarification order, my lord, therefore I have filed this application.
It was stated that the writ petition is already filed.
Dismissed also, my lord. It's dismissed in the. It's dismissed, my lord. I'm sorry. sir.
Dismissed with liberty to get clarification, my lord.
What clarification after
But to
this?
Pass on this order, my lord.
My lord, I have produced. I have produced. I have myself I have produced. My lordship can turn to the order, my lord. Page number 4.
Then why you are not?
But this aspect having attained in my considerable cannot be opened in the, moreover, when a writ appeal challenging the said order, London seeks permission to move the division, seeking clarification, petitioner is always would have that liberty, no grounds of matter. But this is what they have, wherein I have filed a writ petition.
This very order was challenged.
Order dated 22/2/2024 was challenged. In respect of that, he is seeking modification of the earlier order.
Clarification, my lord. When the writ appeal was filed, my lord, my learned friend has produced the order dated 22/24, my lord. My lordship granted liberty, however, the said order was not forthcoming in the order, my lord. I have filed writ petition, my lord. Since there was no liberty, my lord, I have filed application for clarification, my lord.
Then how can we reopen this one? This
My lord,
petition?
the Supreme Court, my lord, granted liberty when the matter was listed for admission, my lord. My learned friend produced this order, my lord. 22/24, my lord.
No, this nothing survives now in this application.
My lord, in this case, my lord, when I filed the writ petition, my lord, writ appeal, my lord, the matter was listed before the Supreme Court. At that time, my lord, my learned friend produced this order dated 22/24. My lord, the Supreme Court, my lord, granted liberty to file writ petition, my lord. When I filed the writ petition, since there was no liberty was granted, my lord, their lordship, my lord, permitted me to file appropriate application to get the clarification, my lord.
This order, which is the date? January. Write down. When the present, this is IA, interim application comes up for consideration from a learned advocate, learned additional government advocate, Mr. Harish would submit that in respect of the order dated 22/2/24, which is thought to be, which is in respect of with the that is made in this IA, was already challenged
Yes.
in writ petition number 754524, and that learned single judge has dismissed the writ petition.
Observing to get clarification, my lord.
Now what
In
clarification?
the writ appeal to get clarification, my lord, para 5, my lord. Para, this aspect having attained majority.
I
Please,
ordered it at 15th April 2024. Full stop. Same order was challenged, are you sure?
Sure, my lord, 22nd February 2024. He can file an appeal against that order. my lord.
Of the order passed by learned single judge? Come on. The present prayer would not survive. No clarification is needed. The petition application is disposed of as above.
What up? Yeah, what up on that?
And here the
No, no. In part. No, sir.
Bill number 98 for withdrawal of writ petition.
No, my lords. I may be permitted to withdraw the petition, my lords, with the liberty to file a fresh writ petition. They will see subsequent developments subsequent to filing of the writ petition, my
Why
lords.
fresh, why liberty?
My lords, recent developments have taken place in the that had to be added.
Memo dated 25/11/24 figures on record in which learned advocate for the petition seeks permission to withdraw the present writ petition, seeking liberty to file fresh one. The permission is granted, the petition is dismissed as withdrawn. As far as the liberty is concerned, any subsequent development will give rise to fresh cause of action.
Number 99, Mr. Sachin BS.
For petitioner, my lords, I have filed memo for withdrawal.
In view of memo dated 24/10/24, permission to withdraw the writ petition is granted, dismiss as withdrawn.
Once again.
Bill number 100, Mr. Keshav R. Agnihotri.
Lord, this is the complainant, Lord. The
Order is
the
complied.
final order of this honorable court,
No other matter. ये ले लो. हाँ.
4th July 24 is the order of disposal.
That's order
Directing
is
to consider.
Order is complied. I have
Complied
filed
with-
affidavit also, my lords, along with documents.
Well, the endorsement seems to have been given, stating that there is no provision for permission to run the business. Only grievance of the complainant is that permission to run a business.
Where is the endorsement?
Lords, I have filed a
Paragraph
memo, my
six.
lords, along
What
with
is that?
documents on 23rd 11/2024.
The only direction of learn a single judge in his order dated 4th July 2024, while disposing of the petitioner, was to direct the respondents to address the grievance of the petitioner by deciding the representatives. Public legal notice which were produced at annexure A to H in the petition. Within a period of 2 weeks. The said order is made subject matter of the contempt petition, present contempt petition. In response to the notice, respondent has filed. What you have filed?
Affidavit, my lords,
Memo along with which endorsement dated 7/10/24 is produced. Whereby the director and dean Bangalore Medical College and Research Institute has rejected the request, public representation of the petition.
Only one submission. Lord, in that endorsement,
The order stands complied with.
yes,
The petition is
it has been
dismissed.
issued that there is no provision to give permission to run business. But the authority has not specified. what-
Learned advocate for the petition, Mr. So-and-so, so still have a right to argue on merits to assail the endorsement.
I'm
which
not
is not
arguing on
permissible in
merits.
the contempt proceedings. If any grievance survives for the petitioner to about the endorsement, it will be open for the petition to institute independent proceedings in accordance with law, for which this court does not express any opinion.
Liberty.
Number 101, Mr. Varun S.
My lord, I was drawing your lordship's kind of consideration yesterday to the settlement agreement, which is the sole basis on which the award has been passed. Which, my lord, the claimant.
There is no dispute that the sole basis of award is the.
No dispute. I showed your lordship, if my learned friend disputes that, I showed your lordship that it is so. The sole basis on which the award has been passed is a settlement agreement.
The settlement binds you.
My lord,
The settlement binds you.
settlement agreement, even according to them, does not bind them.
But it binds you.
No, I am also saying it is not binding. Both of us are therefore proceeding on the basis that the settlement agreement is not binding. My lord, I showed your lordships why it is not binding. And I was pointing out to your lordships, my lord, yesterday, that the settlement agreement is not an unconditional undertaking to pay. There are conditions in it.
Both of you are arguing so well that every day our views change.
I have not even started, my lord. I only have to point out the settlement agreement and nothing else.
Yes.
No, my lord, please look at this. I was pointing out your lordship, settlement agreement, which your lordships will get, my lord, in volume 2 at page 356.
300 and
356, my lord, it begins at page 356. And then I showed your lordship the pleading with respect to the settlement agreement according to the claimant before the learned arbitrator. Respectfully, my lord. Your lordship gets it at page 357. To this respondent of parties, as your lordship will kindly see at page 357. And now, my lord, may I trouble your lordship to kindly see page 358. Last paragraph, my lord. Whereas, yes, OS, that is the appellant before your lordship, the respondent in arbitration proceedings, and emphasis, that is the respondent here in my lord, entered into agreements POs as mentioned in Annex A with reference to projects with a view to achieve mutual business benefits and capitalize on each other's unique business trends. I'm 358, my lord, I'm sorry. I'm very sorry. Emphasis. Entered into agreement POs as mentioned Annex A with reference to projects with a view to achieve mutual business benefits and capitalize on each other's unique business trends for successful implementation of the projects on mutually agreed terms and conditions. And this term projects, my lord, is defined in the earlier paragraph. Whereas UIDAI registrars, UID Maharashtra, National Institute of Electronics and Information Technology, SECC Karnataka, NPR BME for the states of UP and Bihar, hereinafter referred to as a projects. So, my lord, it is a composite project. And if your lordship will kindly see, my lord, Annex A, which is referred to in that last paragraph, which I just now placed for your lordship's consideration, your lordships may kindly turn to page 363. Annex A, my lord, is detailed at page 363. Service agreement, NEELIT, UID Maharashtra, NPR Bihar and UP, SCCC Karnataka, and then the agreement and then the purchase order references are given, my lord, and the dates are also given. Then, my lord, your lordship may be kind enough to turn to page 359. Next page, my lord. Whereas, emphasis has intimated completion of all projects and submitted invoices pertaining to the same in a timely manner, the total receivables to emphasis, which remains outstanding as on date, is rupees 37.60 crores. Whereas, emphasis was intimated by SOS that some of closing work and correction works were performed by SOS to deliver the project's deliverables, and emphasis acknowledged the same. Therefore, my lord, the 37.60 crores, which was claimed by them, we said, sorry, you're not entitled to that because some work you did not do. Whereas, even though the completed work has been submitted to NEELIT, and NEELIT has so far not evaluated the work in terms of payables and penalties for any delayed submission, and SOS. SOS is the appellant for your lordship, the respondent in arbitration. Whereas, even though the completed work has been submitted to NEELIT, I'm sorry, whereas emphasis was intimated by SOS that some of the closing work and corrections work were performed by SOS to deliver the project's deliverables, and emphasis acknowledge the same. That means, my lord, that emphasis did not complete the work that was assigned to them, which therefore we had to do. Yes, my lord. I'll read it again, my lord. I'm sorry if I did not read it properly, my lord. I'll read it again. Whereas emphasis was intimated by SOS, that is, I told them that some of the closing work and corrections were perfect. Yes, exactly. Exactly, my lord. Well, that's
those were the differences pursuant to which the settlement took place.
I tell you,
Those were the differences. I had a claim. They said, no, your claim is not tenable.
No,
Yes, yes,
no,
yes,
it's not. I
yes,
showed you
yes.
lordship the clauses. That's
Yes,
why.
yes. Oh, that's yes, my
I
lord.
showed you
That's
lordship,
right.
not the problem.
That's right.
And in fact, then I showed your lordship their claim statement, where they say we don't want this settlement. Today,
Amount agreed upon is this minus this.
That's
no,
That's
it is not. I showed your lordship, it is subject to it. It is not minus, my lord, it is subject to. Yes. Subject to any deductions that may be made by NILIT for incomplete works or penalty imposed by them. And we have produced evidence to show the penalty imposed.
Then the agreement is separate itself.
They gave it up. They said we don't want this settlement.
Now we are testing the award of arbitrator.
Yes, our arbitrator proceeds on the basis of the settlement. Arbitrator has not even considered their plea that they don't want a settlement. If they themselves don't want a settlement.
Arbitrator has proceeded on the basis of the settlement.
Yes, yes, madam.
Arrived at and agreed upon by the parties.
Yes.
And awarded the amount.
Yes,
as
madam.
agreed by the settlement.
Yes,
But
madam.
where is the illegality?
The illegality, my lord, is it is against the pleading. It is against the pleading. It is against the claim. The claimant themselves say, we don't want this settlement. If the pleading, my lord, there can't be a judgment against the pleading. That is the illegality. And when we took this plea specifically before the Section 34 court, Section 34 court, my lord, does not even consider it.
Let us say 34, the ground.
The 34 ground, your lordship may see the grounds, my lord. I showed your lordship the grounds that we have taken in 30. We have taken the ground specifically.
Same ground will implant in the 37.
My lord, I'm sorry.
The very ground which are.
Yes, exactly. And 34 court does not consider it.
Below. So while testing your appeal.
Yes,
in the 37.
Yes,
the very ground which are enumerated in 37 will.
Yes,
totally apply.
yes, I agree. I agree. I bow down to what your lordship says.
Law.
That is the law. I can't, my lord, in a 37 expand the scope of challenge. Undoubtedly, my lord, your lordship may kindly see the plea, my lord, that we have taken before the arbitral tribunal. First, let me show that to your lordships. Actually, give me that. His lordship is saying that.
Where is the 30?
Give me that. Respectfully, my lord.
Set aside by the court only party meeting application established under some incapacity. Agreement was not valid.
And it is in contravention, my lord. Your lordship, you can see B. 34(2)(b). The court finds that, my lord, first one is not relevant, my lord. 2, the arbitral award is in conflict with public policy of India. And then, my lord, what is public policy? And in fact, my lord, all this has come up for consideration by the Honorable Apex Court. In a recent judgment, my lord, I showed your lordships where my reading is that the scope of interference at 34 has been expanded. Considering, my lord, the earlier judgment of the Honorable Supreme Court in Sangyong.
That's the main judge.
Yes, my lord. Sangyong.
Important.
Important judge. And Sangyong has been considered in depth in the recent judgment in OPG power. I showed your lordship that, my lord. That's the latest judgment on the point. The court finds that the arbitral award is in conflict with the public policy of India. Explanation 1. For the avoidance of any doubt, it is clarified that an award is in conflict with public policy of India only if, my lord, we are not concerned with 1, my lord, we are not concerned with 3, we are concerned with 2. It is in contravention with the fundamental policy of Indian law. Now, what is fundamental policy of Indian law, my lord, is next. Explanation 2. For the avoidance of doubt, The test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. And then kindly see 2A now, it has been introduced. An arbitral award arising out of arbitrations other than international commercial arbitration, this is not an international commercial arbitration, my lord, therefore 2A will apply, may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Therefore, my lord, we have the concept of fundamental policy, that is, first is public policy of India, fundamental policy of Indian law, and the third one, my lord, is patent illegality. So our contention before the Section 34 court was that the award suffers from patent illegality because the award is based on that settlement agreement which the claimant themselves have given a go-by. Therefore, we revert back to the situation, the settlement agreement. The settlement agreement itself has been given a go.
Or it is against public policy?
My lord, it is patent illegality. No, but claimant. No. My lord, if the award is contrary to the pleading of the parties, then the award suffers from patent illegality, which is the plea that we took before the Section 34 court.
What is contrary to pleading?
Yes, exactly, my lord. That's our conception. There can't be a judgment against the pleading of the parties. It was our contention, my lord.
Their claim was divorce.
Exactly. I will show to your lordships if I... Yes, precisely what I'm going to show to your lordships. The entire settlement is divorce. The entire claim is divorce the settlement. Yes, my lord. I will demonstrate. Now, my lord, your lordship may kindly now therefore look at the claim statement now.
Yes.
That is all. My lord, it was deposited some has been paid to them. All that is of the settlement has already been given to them also.
It is one of the contentions raised by us. That's it.
No, it is not. I will tell you lordships why. My lord, let me now point out to your lordship what, my lord, today my contention is this, my lord. I ask myself the question, can there be a judgment against the pleading? I don't think, my lord, the answer can be yes. Answer has to be no. If I am able to demonstrate to your lordships that the claim statement is divorce the settlement agreement, then that should be the end of the matter. The award must go on that ground. And I don't think, my lord, it can be disputed that the settlement, that the claim, that the award is now simply based upon the settlement agreement, which has been given a go-by even by the claimant in the claim statement. We therefore, my lord, before I read the petition to your lordships, it is going to be, my lord, that we revert back to the situation before the claim, before the settlement agreement, namely their claim for 37.60 crores, my contention that you did not do the work properly, then, my lord, they have to establish with independent evidence that in fact they have satisfactorily done the work and therefore they may be entitled to the whole of 37 crores. Well, so be it. But today I am saying you are not entitled to the settlement amount. If that is 23 crores. And I say, look, you prove that you have done the work to the extent of 37.60 crores, divorce the settlement, my lord, my learned friend's client may get the entire 37 crores. But that requires evidence, that requires pleading, that requires the learned arbitrator to go into the question as to whether in fact the work was performed, not performed, deficiently performed, well performed. Nobody has gone into that question.
Well, whether this agreement is well for. What is well for?
The work entrusted to them to the extent of 37.60 crores. Well, their claim was they raised invoices on us to the extent of 37.60 crores. They.
Let us see what dispute.
Yeah, 312. Page 312 in volume 2. That is the claim statement. They are the claimants, my lord.
After this reward of the arbitrator, in some way this settlement will operate
I'm sorry, my lord.
with respect of some condition.
Yes.
Whether this settlement.
Yes.
operate
No, my lord. According to us, settlement does not operate.
after the arbitrator.
Even then, after the arbitral award, the arbitral after, yes, answer is yes.
Adjustment.
It does.
Agreeing.
Not in the award. Not in the award. The settlement agreement, even if it is taken at face value, 350. Yes, I will.
Your liability arising out of penalty.
Yeah, exactly. That is precisely, that is why, my lord, I kept telling your lordship that this is not an unconditional promise to pay 23 crores. It is subject to adjustment, and the adjustment clause has been given a complete go-by by the learned arbitrator. Exactly, my lord. That is why, my lord, when your lordships asked me, is there a debt arising out of the settlement agreement? I kept telling your lordships, no, it is not an unconditional promise to pay. Why, my lord? Please be kind enough to see clause 2 at page 359. No, my lord, it's not unconditional. And I showed your lordship the document produced to show that penalty has been levied on us by my employer because he's a subcontractor. Because they didn't do the job well. This has been completely given a go-by, my lord. And as your lordships are aware, an arbitrator cannot act beyond the terms of the contract. Arbitrator is bound by the terms of the contract. My lord?
Not dishonest.
No, my lord, it's not dishonest. It is, in fact, their plea is dishonest.
Yeah. Chosen by the parties themselves.
Yes.
Thus, please to get out from the settlement.
My lord, it is their case that they want to get out, not mine.
Your case.
Well, in my case is I am accepting that the settlement is not binding. Let us therefore fight it out on the merits of the case, namely as to whether 37 crores is payable to you or not. Even if it is a question of paying 37 crores, if you prove it, you will get it. Well, I don't understand why the claimant is fighting shy of showing that. Exhibited.
Let us see, let us read the entire.
The agreement, my lord? Yes, yes, yes. I am at page 359, my lord. My lord, may I read the clauses after the preamble? Now it is hereby mutually agreed, declared, confirmed, and recorded by and between the parties hereto as under.
Can be from 359 on.
Yes, my lord, 359 only. I am reading from 359, my lord. Middle of the page. SOS agrees to pay INR 23 crores as full and final settlement, which will include receivables from projects.
What is that receivable from?
That is the money. It should be part of the money that I get from NILIT, my employer. But NILIT placed the order on me.
But in any case, 23 crores is an absolute liability.
No, my lord, kindly see the whole thing. No, the next clause, my lord.
Therefore, we are reading.
Yes,
To
yes.
understand that, whether
Yes.
it is absolute liability.
Yes, 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 I understand. I will endeavor to convince your lordship that it is not absolute and
All
unconditional.
loud thinking.
I know, I understand. Of course, my lord. This money will be called as final settlement money. SOS agrees to pay the amount of INR 23 crores as mentioned below. Your lordships may mark that. Very important. What is mentioned below, my lord? I'm going to read it immediately. And next few words are very crucial. As and when the same is received from NILIT. If NILIT pays me, I will pay you. If NILIT does not pay me, I will not pay you. So it is not unconditional. So that I will pay it from my pocket. Then, my lord, next clause. Why do I say what is below, my lord? Please see clause 2. Both the parties agree to bear liability arising out of penalties or other deductions as may be levied by NILIT in the proportion of 60% to emphasis and 40% to SOS. So if NILIT imposes a penalty, you have to bear 60%, I will bear 40%. That's why I said, my lord, 23 crores is subject to clause 2. And this has been omitted by the subject to clause. Yes, my lord. It is not an absolute liability which I have undertaken to pay. It is subject to two conditions, namely that I get money from NILIT, and if NILIT imposes a penalty, you will bear 60%, I will bear 40%. Well, that's clause 2. Clause 2 at the bottom of page 359. Both, my lord, may I read the last sentence on page 359, my lord? Both the parties agree to bear liability arising out of penalties or other deductions as may be levied by NILIT in the proportion of 60% to emphasis and 40% to SOS. So, my lord, the liability of 23 crores is subject to two conditions, namely my receiving the money from NILIT, and if there is a penalty, you pay 60%, I will pay 40%. All this, if I may say so, without fear of contradiction, has been given a go-by by the learned arbitrator. And this, we have taken it up as a specific ground in the section 34 petition, not considered by the section 34 court. And therefore, my lord, the order is against the law declared by this honorable court in the judgment that I pointed out to your lordships yesterday, where your lordships have laid down how a judicial officer, considering an application under section 34, should apply his or her mind, and how the judgment also should be. My lord, it's a little out of the way judgment because of the anxiety of this honorable court. The 34 petitions cannot be dismissed like that in one sentence. Otherwise, my lord, the whole, I have considered the facts and circumstances of the case. It does not come within the purview of section 34, therefore dismissed. My lord, what kind of a consideration, I ask myself, is this? That is why, my lord, this honorable court said in that judgment, you should advert to each ground. You should say why it comes or it does not come within the purview of 34. If you say it does come within the purview of 34, whether the ground is made good or not, every ground must be considered, is what this honorable court said. I shall show to your lordship the judgment once again, my lord, which I pointed out to your lordships yesterday. It is from the standpoint of that judgment that the order passed by the section 34 court has to be considered. And with utmost humility, my lord, I would say the judgment of the section 34 court does not pass muster of the law laid down by this honorable court. And now, my lord, please be kind enough to see clause 3. Any unfinished work from projects will be closed by SOS. SOS agrees to pay and settle directly 2.8 crores payable by emphasis to cash IT pertaining to Nihilate project. All other vendor payments relating to Nihilate project will be directly taken care of by SOS cash IT upon receiving payments from Nihilate, etc. My lord, that's the rest of it. My emphasis, my lord, is on clause 2 and clause 1, which is, and the learned arbitrator, if I may say so with due respect, my lord, has only looked at clause 1, has omitted to read clause 1 fully, has ignored clause 2, and therefore, my lord, the award suffered from patent illegality. Now, my lord, please see what is the stand of the claimant before the learned arbitrator. Please be kind enough now that your lordships have seen, my lord, the settlement agreement on the basis of which the award has been passed. Right. Wait. I will. All other vendor payment, I'm on page 360, my lord, clause 5. SOS agreed to pay, my lord, clause 4, my lord, I'm reading. SOS agrees to pay and settle directly 2.8 crores payable by emphasis to cash IT pertaining to Nihilate project. My lord, there was some other payment that was required to be made. My lord, that's all subject matter of the dispute today. All other vendor payments relating to Nihilate project will be directly taken care of by SOS cash IT upon receiving payments from Nihilate. That also, my lord, is not subject matter of the arbitration. SOS agrees to open an irrevocable escrow account within 2 weeks of signing of this agreement and advise Nihilate accordingly for making the payments into this escrow account, and money received will be distributed as mentioned below. Subject to escrow account being opened, emphasis shall pay an amount of 4 crores to SOS within 10 days of opening of the escrow account. That is, my lord, emphasis, they agreed to give us 4 crores as in by way of a loan.
The escrow account relates to the payment of 23 crores?
No.
Yes.
No. Yeah. Escrow relates to the payments that have to be received from Nihilate.
Foreign.
Yes, foreign. And the amount and
That's right, man.
The
The amount from Nihilate is supposed to come into the escrow account and then distribute.
then distributed. No, it's not. It's not.
It is. It is. The money should have come into the escrow account. But the second part of clause 6.
Escrow amount is, escrow account is for both.
That's right.
23 crores. Not that I paid 23 crores from my pocket. No, let me clear.
No.
But the escrow account may operate in respect of the payment which may come towards 23.
Yes. Oh, yes, yes, that is correct.
Or more.
Or more.
What eventually came was less.
Having any impact.
Impact. Okay, exactly.
What the dispute arose when they in fact diverted the money from the escrow account. That's
No,
right.
it has no, in fact, it has no bearing on the arbitration. Then, my lord, 6, your lordships have seen. 7, sub-gross SOS within 10 days of opening of the escrow account for settling vendor payments as mentioned above. That is the money which they lend to us, we need to open the escrow account by completing the documentation required by each party. 8, in the event of a bank guarantee has to be submitted to NILIT for payment to be released, emphasis will get the bank guarantee issued to NILIT, and all charges for issuing the bank guarantee shall be shared between emphasis and SOS at the ratio of 60% and 40% respectively. This is very important clause. If it was an unconditional commitment on my part to pay the respondent emphasis, then why should emphasis give a bank guarantee to NILIT? Because NILIT would have withheld the amount. They have said, no, give us a guarantee that in the event that the money has to come back to us, you must give it back to us. This is a clear indication of the fact. In addition to clause 2, my lord, expansion, my lord. My lord, NILIT, my lord, is called Nash.
The government.
Is the person, is the authority which is administering the UIDAI.
Is a coordinating authority for data collection for Aadhaar card.
Aadhaar card. UIDAI, my lord,
Coordinates amongst various states and agencies. It is a coordinating agency of the government. It will appoint, it will float tenders for various states. No. Not.
Only to it has only to this extent of clause 2 of the settlement agreement. Both the parties agree to bear the liability arising out of penalties or other deductions as may be levied by NILIT. If NILIT levies a penalty, then it has to be shared in the ratio of 60%, 40%. Not, NILIT is not a,
there is nothing on record to show that any proceedings are pending
that is,
or that NILIT has imposed any penalty. NILIT has released full payment and the chapter is closed. As far as NILIT is concerned, the chapter is closed.
That is my learned friend stand, but I would respectfully not agree with my learned friend. I will show to your lordships a document which is coming from NILIT where they have imposed a penalty. Now, arbitrator ignores all that. Now, where is this adjustment, I ask myself, insofar as clause 2? I can understand, my lord, if the arbitrator has said, I have considered clause 2. After adjustment, I still think so much money is payable. My lord, then, my lord, right or wrong, arbitrator is right. I concede that position. That is a law. But there should be, you cannot ignore the terms of a contract. That is a patent illegality. My lord, yes. Now, my lord, your lordships have seen. Now, please go to their case, which is at page 312. 312. That is the claim statement before the arbitrator. Interestingly, my lord, giving up the agreement on, they want to give it up on the ground of fraud and they have filed a criminal complaint also. I've shown to your lordship that. And what is the effect of alleging fraud in the light of this claim statement having regard to section 16 of the contract? I'm sorry, I want section 18 and 19 of the Contract Act. No, my lord, your lordship may kindly see the statement of claim. My lord, kindly see para 5, my lord. I'll read quickly, take your lordships only to the relevant portions of the claim statement in support of my submission that they have given up the settlement and the claim is may divorce the settlement.
Sorry, yes,
Trouble your lordship, you can see page 313, my lord.
3-1.
The claim statement begins at page 312. Kindly see, my lord, 313 at paragraph number 5. I will only point out, your lordships, what I think are relevant for the purpose of the present case. National Institute of Electronics and Information Technology, hereinafter referred to as NILIT, is an autonomous scientific society of the Department of Electronics and Information Technology, Ministry of Communications and Information Technology, Government of India, which invited bids for providing managed data digitization services for creation of Aadhaar enrollment and National Population Register for usual residents of rural areas in India. The respondent had been selected as one of the successful bidders, known as Managed Service Providers, MSPs, or also as enrollment agencies for collection of data in specified locations in various states. Thereafter, the respondent entered into a mutual arrangement with the claimant in respect of substantial portions of the work to be carried out in the states of Karnataka, Uttar Pradesh, and Bihar, pursuant to which the claimant and the respondent entered into agreements/purchase orders with reference to various tasks on mutually agreed terms and conditions. Now, para 7. Upon completion of the work, this is important, Manu, the claimant raised its invoices on the respondent as of July 2016. The respondent owed a sum of rupees 37.60 crores to the claimant. Para 8. Pursuant to negotiations, respondent represented to the claimant that if the claimant were willing to settle for a lesser amount, the respondent would release the funds so that the claimant would receive the money quickly. Next few sentences are crucial. Respondent thus induced the claimant to enter into a settlement under which the claimant was misled into agreeing claimant are they, my lord. So they are alleging misrepresentation. And I'll show to your lordships what is the consequence of misrepresentation. And see the prayer in this. They have themselves given a go-by. But I am reading the 5th line in para 8.
Lesser amount is
27.23 crores. Lesser amount is 23 crores. The full amount is 37.60 crores.
What is the settlement amount?
23 crores.
Lesser amount is 37.
No. The higher amount is 37.60. 23 is the lesser amount which is subject matter of the settlement.
That is what the allegation.
That is the allegation. They said we misled them
in entering into
entering. No, they're giving it up. That is the consequence of. And then interestingly, my lord, now they don't restrict.
This sentence, does it mean that?
No, certainly not. Because there are subsequent pleadings, which I will also point out.
You are saying that you are induced
to agree to a less. I am saying that you owed me 37.
Inducement led to you sign the settlement.
That's
exactly.
You promised to pay me 23.
We misled them. And they have filed a criminal complaint alleging fraud.
The case that I set up before the arbitrator and elsewhere is that you owed me 37. You promised to pay me 23 as soon as you receive it from NILAT, provided I give up all claims and you give up all disputes, everything. Therefore, you induced me to agree to 23 instead of sticking to 37.
So therefore, you are backing out of settlement.
I am getting out of my claim for 37.
Not backing out, going out of settlement.
They are.
I'm not.
In fact, the prayer in the claim statement today is give me 37 crores.
The subsequent pleadings will demonstrate.
That's the problem.
So therefore, the argument of the appellant is that settlement is only a poser in the total area of dispute. A poser. That out of 37, 23 yes.
That is what they are trying to make out a case as.
You are asserting that we are entitled to 37, not 23.
No, I am not, sir, it is not my case before the arbitrator or at any point of time before any forum that I am entitled to 37.
My lord, what, my lord?
My claim has at all points of time been restricted only to
that-
23.
Answer to that.
Only to 23. My claim has been restricted to 23. My prayer
It is,
is
I
23.
think my learned friend is wrong.
That will.
My learned friend is wrong there. I showed your lordship their prayer in the claim statement. It is for 37 crores.
He is saying 23 crores.
No, my lord, kindly say the prayer. Why should we have a controversy about what is there in the, please be kind enough to turn to the prayer at page number 320. There is not any controversy about that, my lord. (23), kindly see B and C. The total of that comes to 37.6.
See this paragraph 27.
Paragraph 27.
29.
Cause of action arose on 15/7/16 when the respondent
Induced.
Yes, my lord. I was induced and I remain induced. I'm agreeing that you brought me into the settlement agreement.
Therefore, the submission on their part is that this is
My lord,
Go by.
my lord,
out of the clutches of
content, my lord, that would hold good if the contention of inducement was followed by a prayer to set aside the settlement agreement. Neither I say so nor he says so. In fact, his pleadings are also to be seen.
Even this is all the larger, I said loud thinking.
Loud thinking, that's
Even
right.
Even all these things. When the arbitrator is awarded 23 lakhs, would
No, my lord, the arbitrator unfortunately does not say, you have done the work to the extent 23, therefore I give it to you. My lord, if the arbitrator had said, you have done the work for 23, I give you 23, my lord, I agree. But the arbitrator says, don't worry about anything else. 23 is what is mentioned in the settlement agreement, therefore I give you that.
No, actually,
One minute,
no,
let me
on facts, my
let me
lord,
complete, sir,
actually
please.
what came was 17 only. The
Let me-
arbitrator
let
divided,
me
distributed
complete,
17.
Please. I mean, I think please don't interrupt me, sir. Let me complete. But please be kind enough to see paragraph number 29 of the claim statement at page 320. And all this was urged before the 34 court, not a consideration, my lord. This is why this is a case where this must, I would first plead, my lord, that this is a case where this order of the 34 court is, if I may say so with all the humility at my command, my lord, is not a judicial order. There's no judicial application of it. There should be not judicial application, there should be application of judicial mind. None. And it is, I say so, my lord, with a lot of restraint and responsibility, my lord. Commercial courts, my lord, have a special role to play in the scheme of the Commercial Courts Act. In fact, judicial officers in commercial court have to exhibit a level of commercial understanding of commercial matters. That is the reason why, my lord, which prompted this honorable court to write all that in that order.
Now let us see this and we, for the day.
All right.
These prayers in the.
Can you see para 29, my lord?
Yes.
In these circumstances, claimant pray that this honorable court be pleased to, in the interest of justice and equity, to pass an award, directing the respondent to pay the claimant a sum of rupees 4 crores together with interest at the rate of so and so per annum 25/1. That has been paid, my lord. That's not an issue. Right? Am I right? 4 crores has been paid. That is the money they had lent us. That's been paid. That's not an issue. No more. Now, my lord, please see B. Directing the respondents to pay the claimant a sum of rupees 23 crores together with interest thereon from 25/1/2018 until payment and or realization. My lord, if the claim was restricted to what is set in the settlement agreement, then with B, the prayer should have stopped. Give me 23 crores. That is the settlement agreement. I am happy. I will go home. No, kindly see D, C now. Not only give me 23 crores, the difference between 37.6 and 23, 14 crores, please give it to me.
But where is your case that you are?
I will next month.
No, you are liable to pay less than 23.
I have said so in my defense statement. I showed your lordship that. In my defense statement, I have said it before the arbitrator.
That you are not liable to.
Yes.
Even
Yes. I am saying they are not entitled unless they show that they have done the work properly. Yes, my lord. I have said that.
In your reply.
Yes, my lord, in my defense statement before the learned arbitrator. Now, my lord, please see prayer C, my lord. With that, I shall not detain your lordships anymore.
14 lakhs.
No, 14 crores.
14 crores.
Now, my lord, 23 plus 14 is that 37.60 crores. Exactly amount they have claimed. My lord, if really they wanted to stick to the settlement agreement, then their claim statement should have stopped at 23. Now, how does this 14.63 crores come, I ask myself? That is because of the difference between 37 and 23, the 14 crores. They have given up that settlement agreement completely. And there is another paragraph in the claim statement as to how they have arrived at this 14 crores. They say it's the difference between 37.60 and, kindly see, my lord, page 319. My lord, I don't want to detain your lordships, my lord. I shall continue whenever your lordships post it.
Some other engagement will.
I know, my lord. I know, my lord. I saw that. I saw that. I saw that.
Take 5 minutes. Now.
Please see page 319, my lord.
Yeah.
Please see page 319. They say this 14 crores is the difference between 37.6 and 23.
Will also address us.
Yes.
That if a party wants to rescind
yes.
the contract.
Yes.
Whether it can be done by conduct or there must be in writing.
No, man, it can be done by conduct. It is their plea. If they have rescinded, I have accepted the rescission. In my defense statement, I said, okay, you don't want it, don't want it.
So your plea is that by their conduct of invoking the arbitration, they have rescinded the settlement.
By virtue of what they have said in the claim statement itself, they have rescinded the, and therefore, my lord, kindly just see for a minute, my lord, the provisions of the Contract Act. What happens if there is undue influence, that is inducement or fraud? My lord, they also file a criminal complaint against me alleging that I have committed a fraud by asking them to enter into a settlement agreement.
Is it so? Is it so?
Yes, it is produced. It's produced an exhibit. Exhibit R13. Now, they can't on the one hand say the settlement agreement is vitiated because of undue influence and fraud. On the other hand, say, please enforce it. And arbitrator, my lord, enforces it. 34 court does not consider it. Consider my plea.
They are not saying it is undue influence.
No, they have said induce, and they've said fraud in the complaint. Exhibit R13. They have said cheating, they have said fraud. I told them I did not have any intention. If a contract has been entered into by fraud, what is the effect under the Contract Act? The contract is voidable. They have avoided it by asking for a prayer of 23 crores plus 14 crores. But if the prayer of 14 crores was not there, then this plea that I am now urging would not be available to me. That is why, my lord, I am saying they cannot approbate and reprobate. If they have taken the plea that they want 37 crores, dehorse the settlement, then they can't tomorrow say, no, give me 23 crores under the settlement. Our arbitrator cannot do that. That will be against the terms of the contract.
We'll continue.
Whenever
what you are showing about this?
My lord, please see, my lord, section 16. And what is that defines undue influence? Section 17, my lord, defines fraud. And kindly see, my lord, 19.
Misrepresentation.
19.
Misrepresentation.
Misrepresentation, fraud.
19.
They allege, my lord, section 16, my lord, defines undue influence.
Voidability.
Yeah, that is, my lord, that is 19.
Yes. So
it is voidable. It is not void. I concede, my lord. Now, by their conduct, they have avoided it. They have avoided it. And I have accepted it. In my defense statement, I say, all right, you don't want the contract. Well and good. Now you prove that you have done the work to the extent of 37.60 crores. Maybe if you do it, you will get more money. This is the point in the case, my lord.
So this will go on at least in the next week.
Whenever your lordship give me date, we'll come back.
Tomorrow or?
Tomorrow. Whatever.
We'll continue. Whenever time permits, we'll continue.
Whenever your lordship.
Time permits, we'll continue.
Yes, madam. I'll be here. I'll be here.
Tomorrow at 3 o'clock.
Very well.
We'll see. This should have been really considered, my lord, by the section 34 court. This is why, my lord, I beg your lordship's pardon, my lord, for reiterating my first submission. All this must have been gone into by the 34. Your lordships are now called upon to go into all these questions without any application of mind by the 34 court. Nothing, my lord, if I can say, without fear of contradiction. Set out the contentions, set out the judgments, set out the pleadings. Therefore, I think there is no case under 34. Great.
Bill number 8, writ petition 26-954 of 24 to Pramod B.
Petitioner. So having held that 226 powers can be exercised, notwithstanding section 22, on the ground of breach of natural justice, we have partially allowed the petition by issuing following directions. Order dated 20th May 22, passed by the NGT in original application 54 of 15 is set aside, insofar as and to the extent it records finding that Messrs. Madras Engineering Group and Center has contributed to pollution. The aforesaid order dated 20th May 22 of NGT is set aside also insofar as it confirms the interim order dated 23rd September 2021, ex parte imposing on the appellant the environment compensation rupees 2 crores 94 lakhs 60,000 on the alleged ground of so and so, so and so. The setting aside of the order and the finding as above are on the sole ground that they are passed without hearing the appellants. The matter is remitted back to the NGT to decide afresh the question of imposition or otherwise of the environment compensation, and to decide as to whether the appellants are liable to pay such compensation after extending opportunity of hearing to the appellants. The NGT shall permit appellants to produce all the documents and give personal hearing. The appellants, however, shall be obliged to deposit amount of rupees 1 crores with the pollution board in view of order dated 21st August 2024 passed by the NGT in the appeal number 53 of 624. At the same time, the said deposit shall remain subject to the outcome of the aforesaid exercise. The parties shall cooperate with the NGT in expeditious completion of the exercise of deciding effort.
Grateful for the indulgence. Highly obliged.
We have not issued the time-bound direction because of it is NGT.
Probably the first judgment, perhaps, which has dealt with the interplay between section 22 of the NGT Act and Article 226.
No.
No, apart from in our High Court, not the Madhya Pradesh, that has been dealt with.
In a recent judgment of Supreme Court, I must thank to my brother, he has found out that the Supreme Court has observed against the NGT about frequent passing of ex parte orders.
My experience is your lordship's bench always goes beyond what the council would submit.
No.
There would be some 1 or 2 new judgments which we have not cited in this judgment. I am grateful to your lordship.
Great. We'll get tomorrow.